Hey everybody, y'all can be seated. All right, I know that some motions in limine just got filed. I haven't even had a chance to look at what those might be yet. Has the state seen them?
No, Your Honor.
Okay, well,
I'm pulling it up now.
Is Mr. Sprinkle available right now?
We can find out.
Have him come over here.
Your Honor? Mm-hmm. Can I briefly address something before?
Yeah.
Good morning, Your Honor.
Good morning.
I appreciate you forwarding to us the ex parte communications you received from Madam DA Fani Willis. Mm-hmm. Given the sensitivity and the history in this case of ex parte meetings or maybe communications, would you just please request the state? I understand probably what was behind that communications, and of course it is great for a boss to buck up an underling who has perhaps been attacked or maligned, but I don't believe that, and I don't think the court does either, that the court should have been copied on that communications, especially one that reads maybe more like a campaign ad with a source story in it than anyway, I just don't believe it was appropriate, and I would just ask you to please ask the state to halt any future communications ex parte they might want to have with this court. That's all I have to say. Thank you, Your Honor.
Yeah, it's a shame that the court would even have to say something like that, but can you all please communicate to everybody in the DA's office to not have any sort of ex parte communications with the court? And y'all may not even know what I'm talking about because I don't think either of you was copied on that email, but Ms. Love was. Ms. Hilton, you were as well?
I do, Your Honor, and I don't know, I know exactly what you're talking about. I think we have a different perception of direct communication with the court, but we will make sure that.
But the court was copied on it. And it could have been an accident, but
and Your Honor,
it should have been careful.
But the state did not have the initial conversation with the court. That was a community member, and it was very much a reply. Also, was not a direct communication with the court, but we understand the court's perspective. We understand what the court is saying.
Oh, excuse me. I just need to take issue with the fact that it wasn't a direct communication from the court. I'm sorry. Excuse me. Can you hear me now? I didn't mean to act like Max Sharp. I take issue with any type of suggestion that this was not a direct communication with the court. It went from Madam DA Fani Willis to this court. It was a direct communication to this court. It was inappropriate. It was praising Georgia's RICO statutes to the court, which again was not appropriate, Your Honor.
Frankly, I think it might be a good idea to print out the email and make it a court's exhibit to this record. But I think what Ms. Hilton was just saying was that the original communication was not from the district attorney's office. The original communication was, I don't know who this person is or where in the world they are, but some member of the world, member of the public, emailing Ms. Love directly, but copying several other people, the court included, because of course our email addresses are a matter of public record. And, you know, I basically ignored it and deleted it. But as you all know, because I forwarded the next communication to everybody, the elected DA, Ms. Willis, made a decision to respond and directed that response to Ms. Love, but kept everybody, including the person who had made the original email communication, and the court on her response to Ms. Love. And I believe that to be ex parte, and that is the reason why as soon as I read it, I had Ms. Persifield forward it to all counsel, because I don't think that should be going on.
And I certainly appreciated that, Your Honor.
And the court really has ignored entirely the substance of the communication, because the court is not making any decisions based on whether I think the RICO statute is good or bad. That's not what judges do. The legislature enacts statutes. I apply them hopefully correctly.
And I have no
or
concern.
whether anybody thinks any attorney is doing a good or a bad job. I'm just sitting here trying to follow the law.
Yeah, and I'm not concerned about any impact on the court from that communication.
Yeah.
It's just the
Shouldn't be
communication
happening.
itself. Thank
Yeah.
you.
So, Ms. Persifield, if you don't mind printing that out. And I have no idea what court exhibit number we're on, but if somebody can figure that out, we'll number it, court's exhibit number, whatever the next one is. Do you know?
Your Honor, our numbering system is broken down by act, which is why we have the different letters. So
Oh, no. Court exhibits.
I will check that, Your Honor.
We don't know, Your Honor.
I mean, I don't know either, but somebody does. The court reporter, or the last court reporter, maybe. But anyway, we'll get that figured out and make that a court's exhibit. Okay.
Mr. Sprinkle is on his way.
Okay, thank you. So I can't imagine that I am going to grant motion in limine number. Is it numbered? This one's not numbered. But the motion that requests work product of the defense of the prosecution, but I haven't gotten through the entirety of it yet. Nor, I suppose, has the district attorney, and they would be entitled to respond, but that just doesn't seem like an appropriate thing to do. I'm going to give them a chance to take a look at it and digest it and respond. All right, I think probably on all of motion number 65, I'm apparently looking at them out of order, but, and number 64, we're going to give, we might be able to take them up this afternoon, but I'm going to give the prosecution, at least through the lunch hour, to respond to those. So we'll address those after lunch. Okay.
Your Honor?
Yes.
I will say that I know this morning we're going to be discussing some of the Instagram content of Mr. Ryan, and I think the argument which comes up in number 64 is also going to be relevant during those discussions.
Okay, I didn't even look at 64 very carefully, honestly. Thought I would look at it at lunch as well. So let me take.
Now, I certainly will take a look at it too, because I always appreciate Mr. Steele bringing me the law I need.
Okay, well, let's turn for now to the issues that we're going to tackle about the evidence surrounding Mr. Ryan. Let me find my notebook. All right. Did the state get a chance to look at the law sent over about the in-life photograph and what y'all's position on introducing that photograph through the mother?
Yes, Your Honor. We'll meet with Ms. Holmes again, but I don't. Good morning. We'll meet with Ms. Holmes again. In our previous meetings with her, she has not been overly emotional about this case with involving her son. Her being on stand will be very limited to getting in the photo, and then she will be completed with her testimony. And so we believe, just given the witnesses that we have, that she would be the best witness to enter into that photograph. Ms. Smith is the individual, we believe, assisting in setting up this homicide. Mr. Uten and Mr. Mitchell, at this juncture, in all honesty, are not very cooperative. And so those individuals to bring in this picture of Mr. Holmes, we believe would be inappropriate. The mother can do it.
Honestly, I can't hear that one either.
The mother can bring in this photograph. She will be up here for a very limited purpose, and we believe that it would not violate Good or any other of the other.
That mic is not working.
It's on.
You have to hold it closer to your mouth.
Okay.
So you believe that whichever one of those witnesses that was in the car, if you said, is this whatever the person's name is, they would say, I have no idea?
It's very possible, Your Honor. At this juncture, all of our witnesses who come in here should be able to answer simple questions. Unfortunately, do not. I mean, we've seen it time and time again, simple questions.
Okay, you know what? How about try it with one of them, and if they refuse to identify the photo, then call the mom. Okay?
Yes, Your Honor.
All right.
And then, Your Honor, also for the in-life photo, Mariah Smith, who's going to be a witness, they're going to show her a photo that she posted on her Instagram anyway. So having two photos of Mr. Holmes would be cumulative.
Your Honor, we will follow the court's instruction. We will try to get it in through one of the other witnesses.
Okay. All right, and then, I mean, if it's already, it's not the same photo, is it?
No, Your Honor.
Is there going to be some other purpose for the Instagram photo with, what page number are these people on? Do y'all know? Okay, Miss Smith, the Instagram photo of Mr. Holmes, you'd be using it?
If we choose to, that's one of the pictures that we place in the items to discuss.
Okay.
So we are deciding, as we would with any witness, what evidence we're going to admit, so we may or may not admit that Instagram.
Okay, well, if there would be no other purpose for it, then it would be cumulative. There may be some other purpose they might have.
Your Honor, I expect that photo to come in through Ms. Smith. She testified at the original trial. When she spoke to officers, she said she spoke to the victim every day at trial. She said she'd never met him before that night. And of course, she's posted a photo of him on Instagram. So we certainly anticipate bringing it in to impeach her from her trial testimony that she didn't know him.
All right, but I mean, that would be after you'd be cross-examining. So I would imagine if they ask the same question, they could do the same thing.
Sure.
All right.
Right.
Yes.
Good morning.
Good morning.
Good morning, Chair. Good morning. Your Honor, in the case you referenced, which is G-U-D-E, Good, versus State 313 Georgia, 859. It's in Division 2B, as in Barry. It's 2022 case. And I've litigated this, and I know the court said it yesterday. In a murder case, God forbid, the in-life photograph is relevant because you have to show that the person was alive, and then is the corpus delicti is no longer living. But this is a conspiracy RICO count. So the overt acts don't, and that's going to be another issue that we argue before your honorable court whenever you call it, but those overt acts don't have to be proven. It just has to be contemplated that that's what the conspiracy is about, and that overt act has been commenced in some way. It could be a lawful act. But here, the state is putting in, or wants to put in through a parent, the loss of a child. That's just unbearable. And whether they're going to cry or show their emotions or not, I'm not so sure that it has much relevance. I don't believe anybody is going to argue that the person wasn't a human being. And under paragraph 2B of the Good case, the Supreme Court specifically talks about that, it may not even be relevant, and then it would be a waste of time, and it would be prejudicial, especially if another photograph is coming in. So I just want it to be waged that that's the objection. And we're going to have another killing in this case, and I know Mr. Williams is not involved in these, but it's wearing on a jury, because those things go back to the jurors during deliberation. So I would like the court not to include an in-life photograph, except obviously Instagram or something like that if it's coming in anyway. Thank you.
All right, well, we'll see how it ends up coming in. Okay, let's, I guess the autopsy photos, there's been an offer by the defense for Mr. Ryan to stipulate to the cause of Mr. Holmes, the manner of Mr. Holmes's death.
Yes, Your Honor. In discussing with defense counsel, we asked if they would be willing to stipulate to the autopsy report and the autopsy photos. They've decided they do not want to stipulate to the autopsy report and photos, but only to the manner of death. while we understand that Mr. Holmes is only charged with the RICO count.
Mr. Ryan.
Excuse me, Mr. Ryan, I'm sorry. Is only charged with the RICO count, and the murder is an overt act. We still have to show or prove the overt act for the jury to believe that it is a part of the conspiracy. And with that, Your Honor, Ms. D. Williams in her opening statement didn't say these words exactly, but alluded to the fact that her client was innocent of the underlying murder, which was the overt act in this case. I think her words were similar to, he's here, he's been convicted, but that's because he didn't have a good defense, something to that effect, and that was stated in opening. So the state, we believe, still have to prove the underlying overt act, which is the homicide. Initially, the state was trying to avoid calling Dr. Sullivan and an ability to get in or I think we showed the court 3 pictures initially. Defense objected to the omission of those 3 pictures, and so the state at this time is prepared to call Dr. Sullivan for the limited purposes of talking about Mr. Holmes' injuries and admitting into evidence at least 3 photos. We don't intend to, honestly, we would ask the defense that they would stipulate that Dr. Sullivan is an expert, so we don't have to go through that line of questioning, but be able to prove our case, show that how he died, the manner of his death, and those 3 autopsy photos. We don't believe Dr. Sullivan's testimony would take longer than 10 to 15 minutes if we're able to get directly to the point of how he died, where his injuries were, and we would conclude our testimony at that point.
So what is the defense willing to stipulate to?
That his cause of death was a bullet to the brain, to the head. That's about it. And then the 2 victims that were also in the car, they could testify that they saw him in the car. They saw him, I guess, go over. Who else could testify? And then that's about it. I mean, I don't understand why they need the autopsy photos. So that's why I have the 401, 402, and 403 objection. They're only doing this to inflame the jury. There's no reason to bring in the autopsy photos.
Okay, well, they hardly picked photos that would inflame anybody.
Well, if seeing a 15-year-old on an autopsy table, which is what they did in their
Well,
opening,
you know
would
what?
inflame the
He got
jury.
killed.
He did, and they did a murder trial, and my client was wrongfully convicted.
Well, if you're making that argument, then they are entitled to prove it. So you will not stipulate to the medical examiner's expertise?
She was already admitted as an expert, so yes. I thought yeah, we'll stipulate to that.
Okay, great. All right, let me see the photos again.
Yes, Your Honor. May I approach, Your Honor?
Yes. Thanks. All right, I'm going to permit them. Thank you. All right, did y'all give me a sheet of paper that had what y'all had agreed to and what we still needed to litigate on Ryan or not? I mean, it would have been an email, but.
We did not, Your Honor, because we have been going back and forth. We can, when we get to those pictures, we can let you know what we've agreed to, Your Honor.
Okay, so what would the best thing to do be pull up a the Dropbox link?
Yes, Your Honor.
Okay.
And Mr. Sprinkle is here, Your Honor, if you wanted to.
Okay.
He just walked in.
Hi. Can you take the stand for me? Yes. And I wasn't going to do this right now, but when I read that, go ahead and sit down. You're sworn. You're already sworn. You've been a witness in this case for days on end.
Yes, Your Honor.
Okay, so you're still under oath, and I'm going to recall your attention to, I think it was the last day of your testimony, but it was, there was a laptop on the witness stand, and you accessed it.
Yes.
And you actually did that without anybody asking you to, or asking the court's permission. But can you tell me what all you looked at on the laptop?
Yeah, I had my supplement, that 140-page document, and I also had some of the stuff that I pulled during the case. Everything that's already been turned over in discovery, just in case I need to refresh my recollection. But primarily, it was just it was a digital version of the report that I had on the stand. That was it. So I could do word searches. So if I was asked a question, I wouldn't have to be flipping through pages and looking for things.
Okay. Was there any point in time when you accessed anything else other than that report and the files that were connected to that?
No.
Okay. Did you in any way read any communication that came in at any time from anybody?
No, I wasn't communicating with anybody. I didn't have email open or anything like that. All I was looking at was the report and the digital media, like the discs that I brought to the stand with me, that stuff that was on the discs and the stuff that was turned over in discovery. That was it.
All right. We may call you back at some point with regard to this a motion that has just been filed after lunch. Are you going to be around this afternoon? And I don't know whether you'd be needed for that or not. Haven't read it in detail, nor do we have a response from the state yet. But would you be available this afternoon if we need you?
Well, I'm just one floor up, Your Honor, in courtroom 2B. I do have a couple of cases, but I mean, the short answer to your question is I will be in the building in the moment I can peel away.
And I don't know, like I said, whether you'll be needed or not. But all right. Thank you.
Okay.
Okay, so let me get this Dropbox link open. Is it the same one from yesterday?
Yes, Your Honor. It's titled 9 October Centralized Motion Folder, and there's a subfolder in there that says Acts 79 through 81.
Okay. Yeah, the hardest thing for me is actually finding the email again. So
I can resend
I can
it.
forward it.
Well, I'm sure Ms. Pursfield can probably do that faster than y'all.
It was 11:36 on Tuesday.
Oh, here it is. Where did it go? There it is. No, that's something else. No, I don't have it. No. All right, so if y'all, I've got it up now, so if y'all want to just let me know which ones we're going to need to take a look at.
Your Honor, I think we should start with, so there's a PDF titled 11 October Ryan IG thread. Defense counsel in the state, we have had a couple discussions and gone over what we're introducing in various sides objections, and that 11 October Ryan IG thread is the most recent from Mr. Ryan's Instagram of the post we will be using that we would be discussing.
Okay. All right. All right, and what would the objection be? What's the objection?
Your Honor, I believe we're looking at page, Instagram 125. We believe this is going to be cumulative of other posts and the testimony itself. This is a post attributed to slimelife.shoddy, which is Wooney Lee, who's planning to testify. I think he would be able to testify to exactly what's in these photographs without the necessity of offering Instagram photos.
Okay, so the one that is page 125, it's not a photo anyway, it's a post.
I'm sorry, kind of screenshot,
Okay.
image, whatever you'd like to call it.
So, Your Honor, and if the court would permit, may I remain seated?
Yeah, that's fine.
Thank you, Your Honor. So the Slime Life Shorty Instagram handle is Wooney Lee, who is he will be a witness in this trial, was originally a defendant. Mm-hmm. And this post is between Mr. Ryan and Mr. Lee. And he posts that he loves Mr. Ryan, he's realer than me. And then at the bottom, it says full throttle about you. The association between both of them, the state hasn't thus far in this trial with the jury, to my knowledge, introduced any evidence about Mr. Ryan and Mr. Wooney Lee's relationship. So this is the first photo we've addressed with the court explaining that. And the date it's posted is February 25th, 2019. The murder in this case is February 23rd, 2019. So the state feels it's relevant, and there's no other evidence introduced yet about this specific topic, so it's not cumulative in this moment.
Overruled. Then, what's the next one? Are there other objections to other of the Instagram posts?
Judge, just on this, the relevance where I don't think we necessarily know who the other individuals in this photograph are.
Okay, are we moving on to, is this 127?
I'm sorry, Judge, yes.
Okay.
We accept your ruling of overruled.
Okay. All right, yeah, no, I just didn't know if we were moving on to the next one or if we were skipping 3 because there was an objection, but.
No, I believe,
Okay. And so the objection would be it's the other people aren't identified?
I don't know if they're relevant to this case at all.
Okay, what is so it's a relevance objection. What's the relevance?
Yes, and Your Honor, may I remain seated as well?
That's fine.
Your Honor, specifically 3 individuals in this picture are, we believe, YSL members. That would be @1Brees, which is Christian Eppinger, @real1_FR, which is Mr. Darius Ford, and Little Non-Life, which is Mr. Durante Beebe. We can block out the other individuals and only keep in the 3 that we know of are members of YSL.
Okay, when you say block out, you mean the tags. What about the picture itself?
When I say block out, the pictures of those other people and the tags of those other individuals.
All right.
That would cure the objection.
Okay. All right, so then 128.
As just the page reflecting the date that 127 was posted.
Oh, you're right. 129, sorry.
We have no objection to 129.
Okay.
And Judge, I will say, we object as far as these being prejudicial and cumulative. We have nothing further to argue as far as objections go. So when we say no objection, it's no further objection to the general objection for all of them.
Okay, so I mean, I'm not going to assume that each one of these has a relevance and cumulative objection, so I need y'all to state the objection for each of them, okay? So you think this is
So it would be cumulative. What are your objections to 129?
We'll withdraw the
Agree
objection.
on that one.
We'll withdraw the objection.
Okay, so without objection. Okay, thank you. 137. Any objection to 137?
No objection, Your Honor.
Thank you. Any objection to 143?
This is also a post with, this is Wani Lee, who's a co-defendant. And so at this point, this would be the second post, so this would be cumulative.
Okay, what's the response?
Your Honor, this is a little bit different because in this post, it says slime is all we know. We can't go out bad, loyalty over love. So it's, again, it's showing, it's for one, using, he's referring to it as slime is all we know. And he's expressing loyalty amongst two fellow gang members, Your Honor, publicly.
Let me go back up and look at that first one. So are you saying when this references slime, what are you saying? I'm sorry, I don't really understand what your argument is.
When it says slime is all we know, we can't go out bad. There's been testimony earlier in Zachary's interview, he says a comment about catching someone down bad, which means to murder or hurt them. So when he says we can't go out bad, slime is all we know, we can't go out bad. It's like the gang is all we know, and it's saying loyalty over love right after that. So it's like we got to protect one another. This is what we know.
So this is more than just the two of them's relationship. This is with regard to the larger gang.
Yes, Your Honor.
Okay, so the cumulative objection is overruled.
Judge, my question with this post and some of the others is going to be, I don't know if we're going to have a witness who's going to come in and say, this is what this person means. I don't think that would be appropriate. If they'd like to say this is what this person means, they should be asking the author or whomever posted it. But the same question Your Honor has looking at it, well, what is the relevance? I don't think it's appropriate for a witness to come in and say, this is what this person means when they posted this.
Okay, are y'all planning to have somebody do that?
So two things, Your Honor. One, all of these that we're currently in is statement of party opponent from Mr. Ryan. But specifically on that issue, the jury has heard from, the first witness was Detective Belknap, who was an Atlanta Police Department gang detective. So a lot of what I'm proffering this to the court of why the state wants it, but
understand.
Each individual post or comment is not going to, some of this evidence is already in evidence in terms of the state has had witnesses testify about gang identifiers, what these mean. So
You're not going to have somebody say this is what whomever the poster was meant because I'm in their head.
No, Your Honor. I'm not going to have someone get up and say exactly what Mr. Ryan meant when he posted this. No, Your Honor.
But y'all can certainly argue that if you want to, if and when we ever get to closing arguments. Okay. All right. Page 145. Any objection?
Sorry, Judge, 143 will take that as an objection overruled?
Yes.
No objection to 145.
All right. 164.
No objection.
Thank you. 166.
Yes. Subject to connection.
Judge, this is one that we had actually discussed with the state that we didn't feel it was relevant or appropriate unless one BS slime could be established who that person was. We were waiting on the state to see if they had an answer of who that would be and if there was someone who would testify based on some evidence in the trial versus just, this is this person.
Your Honor, the state's understanding is that 1B Slime is an individual by the name of Jaborius Greer. Jaborius Greer, we believe, is the nephew of Mr. Williams. And we have had gang experts that have had interactions with Mr. Greer, and we believe that he is also a member of YSL.
All right, well, is that going to come into evidence?
Yes, of who 1B Slime is, yes. Because he's on a few other posts as well, Your Honor.
Okay. Through whom is that going to come into evidence?
I'm sorry, say that one more time.
Through whom?
Investigative Rito.
Okay, and will that have been before or after this?
It'll be after.
All right, overruled. 203.
No objection?
211.
No objection?
236.
236?
Yes.
Objection or no?
All of us in the back, I think we're trying to, I know this is kind of involving Mr. Ryan.
Well, I
but
mean, the evidence is
Right.
coming into the trial, so.
I'm just trying to figure out, I'm in the Dropbox link that Mr. Atkins sent, but you guys are, everyone's referring to as exhibit numbers, and I'm,
It's no. So at the very top right, it says page 240, which I guess must have been of the whole Instagram record. Do y'all see that? So it's in the folder that's, what, 79 through 81? And then I think it's, at least for me, the second entry in there.
It's titled 11 October Ryan IG thread.
All right, and then once you open it, you'll see the page number references, and that's what we're referring to right now. Sure. Okay, so we're on, I think, page 240?
Yes, Judge, we are objecting to the relevant subject to some sort of foundation or connection about what this is about.
Okay.
Yes, Your Honor. We believe 240, the post says Rudy 4L, and it says GVNG, which we've seen for gang, they take out the A and replace it with a V. Rudy is a young man, and my apologies, his actual name is escaping me, but he was a member of YSL that is now deceased. And a number of YSL members either have Rudy 4L tattooed on them, or they have Rudy in some way. They honor this young man. And Detective Belknap has testified about Rudy and about this significance to YSL. And so the fact that Mr. Ryan is posting about him again shows his allegiance to YSL.
Okay. Well, given the testimony that's already come in, seems that's relevant, so overruled. 244.
Judge, we're just asking the ones who've not been identified or won't be identified be redacted out from this image.
All right.
So, Your Honor, because this post is titled Love All Mine and it has a snake emoji, the state, and it's a statement of party opponent, the state feels that all of these, and some of these Instagram, in what we will get to in a little bit, interact with some of these handles. And so the state feels that it's relevant that in this public post, he says, love all my, the state interpreted as slimes, he puts the snake. And so the state feels that none of these should be redacted.
Okay, I see what you mean. Okay, that's fine. Then I will overrule the request for redaction. 258.
Judge, I feel this is highly prejudicial without any sort of connection to this actual case.
Response.
So, Your Honor, this is a 6 firearms, and the one on the far right has an extended magazine. So the state, we have whittled down pictures and reference.
Where does it come from? Like, what's this a picture from?
It's his Instagram, Your Honor.
Oh, right, okay.
And so, yes, Your Honor. So because at this point in time, we've tried, there's a number of pictures of firearms and pictures and videos. And so thus far, we've discussed one today. So the state feels that it's relevant to show access to firearms. It's his own Instagram that, this is a photo he has. So the state feels at this point in time, it's not cumulative or irrelevant that there's 6 firearms, one at least visibly has an extended magazine in this photograph.
Okay, well, given that he's choosing to post this on his Instagram, I'm going to overrule the relevance objection. Page 260 is the next one.
No objection.
All right. 315.
No objection.
So then there's several pages of business records. That's just showing,
Your Honor.
what is that?
So this is Instagram. At the top of every page is going to have business record, but these are Instagram threads.
Okay.
That the remainder of this PDF is various conversations
Okay.
that Mr. Ryan is having.
All right, so Ms. Bossi, if you can direct me to whatever the next page is that you have objection to.
Your Honor, it's going to be the next few pages, which are the number at the top is 400 through 404.
Okay.
I don't believe we have or there will be any sort of identification about who the conversation is between besides Mr. Ryan and another person. Our understanding from the state is this is about selling firearms. And I don't know how that is relevant to this case about Mr. Ryan selling firearms.
All right, and I see that some of these things are highlighted.
Yes, Your Honor. So the highlights, it was to make it easier for both the court defense counsel to follow what the state feels is significant, because the way that Instagram returns come in, you can have multiple threads on different pages. Okay. And so it goes by time of when you get an incoming request. So it can get kind of confusing to follow because it's not just a conversation between Mr. Ryan and one party. It's embedded with others. So the highlights are, I may have missed a couple, but it's to orient. Yes, Your Honor.
Okay. All right, and so there's a relevance objection.
Yes, Your Honor. So this is in a similar category in regards to, there is a number of references to FYE when it says sell me a fire, the state, that is a gun, firearm. There's a number of these in the Instagram. The state wanted to include some of these so that these photographs of guns, it's him talking about actual firearms. Sometimes, I'm not saying this argument has been made or will be made, but in terms of for the jury, his internal discussions about real firearms, right? Instead of maybe they could be a prop, or maybe they could be, these photos we're showing, that this is just showing he has access to and is talking about.
Right, but we're not talking about the photo right now. It's as I understand the relevance objection, it is what is the relevance of him proposing and engaging in conversation about a transaction to buy or trade firearms.
Yes, Your Honor. So in this case, in regards to count 1, it's maintaining armed individuals ready and willing to preserve, protect, and enhance the reputation through the use of violence. It also includes, ease and access to firearms. And so the fact that he is, casually discussing, because this specific one, Mr. Ryan is talking about, give me $250 for my Glock. And the party he's interacting with says, I got a Taurus, I'm going to sell it for $2. So it's simply to show the ease with firearms involving a case with a number of violent acts and his access to firearms. That's why the state wanted to include this. And I can see the court's chagrin, but that's why the state wanted to include this.
It's not chagrin. but I doubt maybe as to the relevance of him wanting to sell a firearm, if that's what this is reflecting.
Yes, Your Honor.
Yeah, I'm going to grant the relevance objection. All right, what's the next?
I'm sorry, Judge, they've taken out a few photos or a few parts since the last time we
Okay,
discussed it.
that's- yeah.
Making sure I only talked about the ones which are relevant.
Appreciate it.
413. So I think we get up to 416. There are going to be a number of pages in here which it's just Mr. Ryan saying slat or just one phrase. And I guess our question is exactly how many of these do we need? Because we've got some images, we've got multiple conversations. How many times do we need to just see the same one word or same one phrase to establish that these are phrases or words that Mr. Ryan uses?
Okay, so I see the one that starts on 416.
Correct,
Is
Your
that
Honor.
a multi-page thing? Or?
It is pages 416 and 417.
Okay.
And the state, again, has whittled down. In the Instagram, there is a lot of reference to these terms, but the state wanted to include some because these are private, direct messages.
Okay, so this would be this two-page
Correct, Your Honor.
correspondence.
And so it starts at the bottom of page 416 where instead of the S, it's the 5.
Right.
And it says slat, and it's between, Mr. Ryan's Instagram is Slime Business Rod, and the person he's interacting with is Maniac with an X instead of the C, Rolac. And so that Instagram handle, I do not know exactly who Maniac Rolac is, but Pete Rolac, Sex Money Murder, founders of that street gang, that Instagram handle stands out. But nonetheless, it's just to show, and the state's not intending to do this 100 times. This is the first time we've discussed it where Mr. Ryan says slat with a 5, and the person responds, what's blazing twin? And then Mr. Ryan says he's basically just hanging out, but he's replacing certain letters like C's with B's. And then the other guy responds right side, and the right side is significant. And so this also has, so yes, Your Honor.
Okay, so that one's the first time we're seeing it, so that one can come in, and then I don't know whether they're going to be more or not, but my ruling might be different if there are more.
So, Judge, from there we move over to page 467, which is where we have a message between Winnie Lee, who was the speaker or the person in the first few photos. The state wanted to show the association with Mr. Ryan saying, "Very yacht slime, WYA, you good."
We're going to withdraw that, Your Honor.
All right, they're going to withdraw that.
All right. Judge, the next one is going to be moving up to the Instagram page number 512.
Okay. And, okay, what's the objection?
So this 512 through 514 is a conversation, I guess, between underscore free Juju, who I don't think we know who it is. It begins on page 512. 513 is a conversation where Mr. Free Juju says, you know, the N-word you robbed named Booley. They're talking about some sort of conflict, allegedly, that Mr. Ryan had where he robbed somebody. Mm-hmm. We feel that's entirely too prejudicial to come in. And the conversation about it continues with Free Juju being the speaker.
So, Your Honor, this thread goes from Instagram pages 512 to 514. And the state does not have, so just, I'm going to follow this thread because to orient the court. So it starts at the bottom of page 512 where Free Juju tells Mr. Ryan he's got to tell him about something that happened today. And Mr. Ryan's like, well, what happened? So the state has no problem to redacting the word robbed. He's referencing someone that Mr. Ryan had previously robbed, but the state wants more so that he's talking about a specific person named Bully. And then Mr. Ryan's like, yeah, I remember the guy I robbed. And then they go further. And so what this individual says is Tobias had got caught for an X, which the state believes is a gun, while he was walking on the back street back from school.
Right.
And then, long story short, this individual Bully draws down on him, as in brandishes a firearm at him, and he's telling Mr. Ryan that Tobias was scared. And so in response to that, you go down to 514, and Mr. Ryan says, were y'all striking on Cleveland? Striking typically can be going in to break into cars and steal items. And he's like, no, we weren't breaking into cars. We were walking to school smoking, and we saw a gun on the seat. And then further on, what Mr. Ryan responds to that in terms of the person letting someone draw a gun on him and not resort to violence back is, y'all are reckless. Why did y'all let Bully draw down on him? Now y'all can't get bust down. I'm going to draw on him on slime. So it's, the state kind of wants these 3 pages for that last line where he says, I'm going to draw down on him on slime, on the gang.
All right, so just redact on the thread, I guess. What are you, just redact, you robbed?
Yes, Your Honor.
Okay. All right, well, that'll cure that objection.
Judge, that brings us up to page 543 through 546.
Okay.
This is another, I believe, series of talking about, I guess, selling bullets.
Given your previous ruling, Your Honor, we'll withdraw.
All right. All right, what would our next one be?
I thought they were taking 696. We already have. My notes in this, Judge, was that the state was going to withdraw 696 because we already had the word slat earlier.
Is that right?
Well, page 696?
Yeah. Yeah, it looks like all that is.
696.
That's correct, Your Honor.
Okay. Thank you.
Let's see. Okay. Yeah. What's this one? Judge, this one, I think we had kind of.
I'm sorry, this one being
I'm
which
sorry,
one?
Judge. It's going to be page 778.
Okay.
Ms. Abbasi, in the court, for 778, the state, we won't use 778.
Okay. All right, and then is the next thing 801?
We had no objection to 801.
And that goes, what, 801, 802, I guess?
802, we discussed with the state, they were going to redact out part of it, which we agreed to, and no objection
Okay.
with that redaction being.
All right.
We're going to redact, Your Honor, the very top, the first text on page 802. And defense counsel in the state talked about this.
Okay, as long as y'all are on the same page.
That's going to bring us up to 819 and 820.
Okay.
This is another one, we don't believe there's any sort of connection to the gang. and how this would be relevant. Again, this is with Free Juju, who we don't know who this is.
Your Honor, the state will, I'm double checking because.
Laughing at the reference to a Hello Kitty.
Yeah. So he's basically insulting because the gun is
Yeah.
small.
Kind of funny.
So, Your Honor, the state will not be, I'm double checking because sometimes there's another thread that's captured on the same page, but we will not be introducing that
Okay.
brief back and forth.
All right.
Page 880, Judge, we feel that the relevance regarding to what the prejudice from this is, based on what the state's understanding of it is, which I don't think it's self-explanatory. Someone would probably have to explain what it means, but we feel it's overly prejudicial with respect to the minimal relevance.
All right, I think probably slide and sticks have already been explained, right? Through testimony already?
Correct, Your Honor. So the state wanted to include this just to show, it's one thing for the state to talk about it, but this is
Right.
an internal Instagram.
Okay. Overruled. What's next?
(903), 904, Judge. This was another relevance about some people talking about going to Club Crucial.
Your Honor, the person that Mr. Ryan is speaking with is, the author is 05E and Drive Slim. That is Mr. Christian McMiller, Your Honor, who unfortunately passed away in March of 2022, and we believe is a YSL associate. So to show his connection with Mr. McMiller is why we have this.
All right, and have y'all already established who that author is, who that other person is?
We will be establishing who that is. We have a few Instagram posts with him and other individuals with this same Instagram handle, 05E and Drive Slim.
Okay, and this would just go.
And it may already be in, there's a picture of Antonio Sledge and him.
Okay.
And I believe that picture is in evidence, Your Honor.
All right.
I'm sorry, Judge. There's
ahead.
a photo earlier on which we did not object to with this same person, so the connection between them has already been shown earlier via photo.
Your Honor, but the conversation continues because this is one of the conversations in which you actually need to look at his conversation with Mr. McMiller and his conversation with Billion Dollar Pink. Billion Dollar Pink towards the bottom of, their conversation actually starts in the middle where he tells her, I'm on the way to Crucial, or OTW, on the way to Crucial. Then, I believe it's a she, bruh, who you with?
Page am I looking at?
903.
Okay, it must not be highlighted.
It's not highlighted.
Okay, all right, I see Billion Dollar Pink.
Yeah, so she's,
Bro, who you with?
bruh, who you with? And then he responds to her, gang. So that coupled with him talking to Mr. McMiller about going to Crucial and who he's with, he's acknowledging that he is with gang to her. So these two conversations actually coincide with each other. So he's setting up going to Crucial with Mr. McMiller, and then he's telling the other person, when she asks who you're going with, gang.
Okay. Okay. Overruled.
The next ones, take one out. They take it. So they. Okay. This one, Judge, is going to be 940, 941. As far as relevance, and I don't know what the probative value is, this is another one, a conversation between Mr. Ryan and somebody, and we don't know who. I don't know how it's relevant.
So this is where, when we started that post where it says love all of, and has the snake emoji, one of those individuals that Mr. Ryan, ats is Block Life OKKY, which is who he's speaking with. So it's someone he's publicly stated as a fellow gang member. And so what he says is, at the very top of 940, this individual, Block Life, says, talking about going to Club LaCroix, about to get dropped off at Big Nick's spot. Big Nick's spot is someone that pops up in terms of a location that that YSL members will go to or hang out at. So, and it's 2823 Waters Road, or sorry, 2830 Waters Road, which is the same house we've talked about to the court with the 911 call and tethered to the murder of Shamel Drinks and the back and forth. So also, if you follow this conversation more, Mr. Ryan in kind of the bottom of 940 says, Slime's gone from the store to the studio. And this person responds like, who? Mr. Ryan uses this term MAJA, but then if you go further, he's like, what studio are they at? And he says, last time I checked, they were at Club LaCroix with Dolly. And there's been testimony about Dolly being Dolly Greer, the sister of Jeffery Williams, about 2 hours ago. So again, this is showing it references a couple of different items in a private Instagram thread of a location of Waters Road, referred to as Big Nick spot, and also tethers, because age-wise, there's a difference. And so it connects Mr. Ryan with other evidence in this trial.
All right, overruled.
And Judge, just to add to that, the part about who was with Dolly, that's not Mr. Ryan as the speaker. I don't think we know who that person is. I'm sorry, did I miss that? We do know who that is?
I don't know his name. I know it's the same person that Mr. Ryan ats when he says, love all my slimes. And then Mr. Ryan responds to that, okay.
Yeah. All right, thank you. Okay, what's our next one?
This is 950, 951. Seems some sort of spat between Mr. Ryan and somebody else. At the somebody else, I don't think we know who it is. So I don't know what the relevance of this is.
So, Your Honor, the state for 950 and 951 will not utilize that
All right,
thread.
thank you.
(1012) or 1012
Okay.
through 1014. Again, we have another firearm gun conversation.
Any significance beyond?
Your Honor, no, the state understands the court ruling that there's one, and the court's ruling may be the same on this at the bottom of 1013. He says, can you sell me some for cheap? You have 2 sticks and about 5 pistols. And then Mr. Ryan says, for sure, we're going to be getting into photographs and videos of firearms, but so the state felt that was significant in terms of the number of firearms, and also, but the murder involves both what would be referenced as a stick or a longer assault rifle and a handgun, no indication, obviously, from this specific text thread that he's talking about the weapons involved in the homicide. This is almost 30 days before then, but nonetheless, the state understands the court's previous rulings about firearms, but that specific
Shows his access to firearms like the ones used in the murder?
Yes, Your Honor.
All right, I'll actually permit the admission of that one.
And the state cannot, thank you, Your Honor, will not use 1012 when he's talking about a different firearm, and
All
will
right.
use 1013.
Okay. And then does 1014 go with it as well, or is that some new thread? Y'all don't need that one, right? It'll just be page 1013?
Yes, Your Honor.
Okay. Yes.
Judge, I want to go back to 1013.
Sure.
This conversation is free Juju saying he wants these guns, which the state is saying, are consistent with what were used. And Mr. Ryan's response first is for sure, but I think that's supposed to be a response to the prior. The conversation is, give me a gun, B word. And then free Juju sends this other, give me these ones for cheap XYZ.
Right.
Mr. Ryan says, for show, I think that's actually referring back to the give me a gun in general, because his next response is, I don't sell FYE no more. And then free Juju says, when you get two, just give me one. And we don't have a response from Mr. Ryan saying, okay, yes, I'll do that. He's actually saying, no, I don't have those guns.
Well, he's not saying, no, I don't have those guns. So the ruling stands.
That's 10, 13, and 14.
Well, my understanding was that they were just going to use 1013. Do you want 1014 in?
I was just trying to make sure I got the right pages.
Well, all right.
That's correct, Your Honor.
It's just 1013?
Yes, Your Honor.
Okay. All right. What's our next one?
We took out 1036 and 1039. Your Honor, if the next two pages were 10, it's just 1039.
I'm sorry, Judge, to back up, if 1012 and 1013 are coming in, then we would want 1014.
Yeah. Yeah. Okay. So my understanding was it would just be 1013.
Yes, Your Honor, you are correct.
Then we would like 1014 to come in because it completes the conversation of I don't sell that anymore.
Okay. So 1013 and 1014.
Your Honor, we're withdrawing, am I looking at the over? We're withdrawing 1036 and 1039.
And Your
Okay.
Honor, the court's version just currently has 1039.
Okay. And y'all are withdrawing that. Okay.
Yes, Your
So
Honor.
then that takes us to 1070. Is there, which I guess would be 1070 through 1073.
The next objection. The next objection we have is starting on page 1109.
All right. All right.
1109 and 1110, this is largely a conversation with somebody else. And I don't think without knowing if that's some sort of a co-conspirator that this is relevant. And I also don't think the relevance of this conversation is evident or has any relevance unless there's someone who's going to get up and say, this is what this person means when they say this. So that's going to be 1109 and 1110.
All right.
So, Your Honor, there's multiple things going on here. In terms of 1109, this person says, he tells Mr. Ryan, hey, Slime, You need to check out this person. He's my brother. I'm trying to scare him. And then Mr. Ryan says, does he say he's slime? As in, like, is he claiming YSL? And then he says, how? And then the guy responds like, yes, he is, but he's my brother. And this thread goes on, and he says, the person who started this conversation says to Mr. Ryan, I just want you to scare him, which the state takes as not, do something more violent to him for if he's really not slime and he's claiming that. And then the bottom of 1110 is a separate relevant portion where Scarface is Demekion Garlington. And when that Instagram handle, it says slat this SB what's up, the state believes that that SB is the nickname for Mr. Stillwell. And so that specific bottom portion of 1110 is a separate reason in this thread. And then they have a video call with one another. And so there's two things going on, and the state can not utilize, so.
The top part.
No.
So, and Your Honor, the part of what's behind this is, like, for example, Mr. Sledge, who's testified before this court, he's on the stand saying anyone can be slime, the judge, the state, whoever. And so this is a private conversation where it's clearly a problem that someone is publicly saying that they're slime, because Mr. Ryan is saying, like, he says he's slime, how? And the person who's telling Mr. Ryan about this says, I just want you to scare him, which the follow-on of that is like, don't do something more. So that's why the state feels it's important, is there's a differentiation. Not every, there is people that are slime, there's people who aren't. And so, and it's a problem if you're saying you are and you are not.
Okay.
But there's no response from Mr. Ryan saying, yes, I'll do it, or I don't know what you're talking, there's no response. This is someone else saying these things about whether he's going to scare him or do something like that.
And Your Honor, I have removed other threads, but I believe this ultimately gets to the point where he says, and I'll try to find where this is. There's a message where Mr. Ryan says, like, what do you want me to do? Kill him? Like, and so I'm pretty sure in my mind it's in, I don't have that included, because the state's trying to be judicial with what we include, but I'll try to find where that is. So it's not, because my thread is only what we're intending to use. But I want to double check, but that is my memory, so I'll verify that right now, Your Honor.
Okay, well, assuming that that's the ultimate response, they could add that response, or we could have an understanding that there is a response that affirms that he's willing to do something.
I'll have to check, Judge, because those
Okay.
pages aren't in here.
Your Honor, I
Yes.
have a concern with this matter, and maybe I'm just not as tech savvy. We're seeing towards the bottom of the page the initials SB show up.
Yeah.
And Mr. Atkins, I appreciate him being clear on this. I'm being told anyways by the state that this SB conversation, whoever's involved, is a separate thread, is what I heard from the discussion
I hadn't gotten clarity on that, so let's, I think I'm as untech savvy as you. So is the person who's saying this SB what up able to see this other conversation?
No, Your Honor. And so to accurate, with Instagram, there's a text thread ID, so they give a specific number.
Yeah.
So if I'm texting Joe Smith, and then a second later, someone else texts me, and me and Mr. Smith keep texting back and forth.
Yeah.
Each thread, you have to search the number. So
Okay.
there will be, this is a completely separate, it's almost like getting a whole other text message.
Okay. Is that why some things are in yellow and some things are in green highlighting?
Yes, Your Honor.
Show that this is a different thread?
That, and to also help be clear for both the state, defense, and the court of what portions, because you're always going to have, for the most part, random conversations in
Right.
one page.
Okay.
And so there will be no evidence or inference or argument that what we were just talking about has any connection with this Scarface, slap, this SB, what's up, and then the video called Mr. Ryan. Those are independent.
So when the state's presenting their case, I'm just trying to think through this. If this is say that over objection, the part we just discussed involving Mr. Ryan and I just wanted to scare him part. Say that's for example, that's admitted, and then the lower part involving slap this SB, what's up, is admitted. When we're publishing to the jury, is this going to be like printed out as two different exhibits with two different text chains, or is the state's plan to just publish this document and then this jury kind of is supposed to figure it out? I'm trying to understand where we're going with this.
No, Your Honor, we would have the witness distinguish that with Instagram, there are different text conversations, so this is a separate conversation. We can ask that very
All right,
specifically.
y'all need to just make that very clear that, because, I'm sure, well, I'm not sure, but there might be jurors who are as untech savvy or unsocial media savvy as Mr. Sharp and I, and so
And
we
we
need
can
to
highlight
make
it
it very clear that this is an entirely separate conversation, that the one who says the SB is in no way, seeing or involved in that other conversation. Yes, Your Honor. All right.
Your Honor, and back to the part about the conversation, I'm brother, what do you want me to do, kill him? The response about killing somebody is a different conversation with a different person.
So, Your Honor, I was just Control-Fing to find where this is. So we haven't gotten there yet, but a couple pages after this is another conversation where Mr. Ryan is talking with someone else, saying that someone's not official. And then he says, he's not. Do you want me to kill him? So that's why I prefaced what I was saying to the court of I want to verify this, but it is, we're going to get to this.
Conversation.
It's a couple pages from where we are
But is
currently.
it the same two people?
No, it's a different conversation where he's discussing someone who is or is not slime. So I apologize for that. It's 2 or 3 pages after where we are.
Yeah, the conversation about the brother, that has no response from Mr.
Okay,
Ryan.
well then, if this next conversation is showing the same thing, and this is more clear, use the next conversation and withdraw the.
Yes, Your Honor.
Or I'll grant the objection, so.
Understood, Your Honor.
Okay.
We would then just be intending to introduce the part between where it says, hey, this is SB,
Okay.
when we were just, which would also eliminate the problem we were just discussing.
Okay,
I'm sorry, I missed that last part.
so basically the objection would be granted as to that first part of the conversation, so they're going to withdraw that and for that purpose. So I guess when we see it in trial, nothing will be highlighted other than the this SB what's up and then the video indicator. With that, so would that take care of the potential confusion issue?
Well,
Seems-
I have a confusion issue and then I have a relevance issue.
Okay.
As I understand these records, and I'm focusing on the part that says SB because that's allegedly something my client goes by.
Okay,
Is that better?
better.
All right, so, thank you. So, as I understand these records indicating someone types or texts this SB, what's up, slat this SB, what's up. And then, that the author is showing Scarface because that's the device that's being used on Twitter, is that?
Your Honor, so it appears that I will assume for the purpose of this conversation that Mr. Garlington and Mr. Stillwell might be together. And so maybe he took Mr. Garlington's phone or was on his Instagram page, and maybe he didn't have his phone and he needed to talk to Mr. Ryan. And so Mr. Stillwell takes Garlington's phone, goes on his Instagram account, direct messages Mr. Ryan and says, hey, because I'm Instagramming you from Garlington's account, this SB, hit me up, or whatever. I think he says, hit my line in a few minutes. And so I think that is probably what occurred.
And then, okay, so by the state's theory, Shannon is on Demikion's Twitter and says,
right?
Instagram, yes, I'm sorry, thank you. And says something to Ryan, and then afterwards there's some video call of an unknown duration.
Correct.
Is that, okay.
Correct.
I'm going to object to, I understand that it's being separated from other discussions, but that in and of itself, I'm going to object for relevance grounds. I don't think there's an issue at this point whether Mr. Ryan and Mr. Stillwell know each other, or Mr. Stillwell and Mr. Garlington know each other. So, I mean, there's no content to any of this. It's just some sort of connection.
You're right. I don't believe, and I'll double check, I don't believe we have any evidence of
Mr. Ryan and
Mr. Stillwell. We have a picture that I think is in dispute, but outside of this picture that we believe is in dispute of if the other individual in that there's a picture on Mr. Stillwell's page that said, and it says me and him, but there's a dispute as to whether the individual is Mr. Stillwell or not. And so outside of that picture, this is what we have to show association.
I mean, at least as far as since I've been here, I don't think we've had that evidence.
Okay. Well, I'm going to say that picture that the state's referring to is definitely not Mr. Stillwell.
Okay.
So
all right.
Okay. So, and just getting back to, I'm just trying to fully understand the text before.
Yes.
The state is no longer wishing to admit those.
Correct.
About scaring him and.
Correct.
And so when this is brought in front of the jury,
will it still be on there even though not highlighted? Is that the question?
Yes.
Because we're not bringing in the top of the other thread. We will probably still highlight it, because I think for ease of the jurors being able to see the conversation, we will probably, yes. We will.
No. What I am asking and what Mr. Shard is asking is when page 1110 gets presented, the only thing highlighted will be Slat, this SB, what's up, Scarface, and then video call event. But will the rest of the text above that
be highlighted?
It definitely won't be highlighted.
Right.
Will it be on there at all?
No, we can redact that. We can redact the
I mean, it would honestly be the other person talking, he my brother, and I just want you to scare him, and nobody's going to have any idea because the page before that isn't going to be presented. So would it matter whether it's on there or not? Because there's zero context to it at that point.
We'd rather have it just redacted out to be safe.
Okay, so generally, that's fine, but generally speaking, are they going to come in looking the way they do with just highlighting, but other random irrelevant stuff's going to be on there?
Yes, Your Honor.
Okay. All right, so if there is other random irrelevant stuff in any of these that is prejudicial, then let me know and they can redact that, or just let them know and they can redact that out.
Yes, if they
Okay.
let us know, we'll redact.
All right, thank you.
And sooner rather than later, as this case may come up sooner rather than later.
Okay.
We'll double check it, Judge, and
All right.
speak to the state about that. It sounds like,
They don't have I mean, they don't need it anyway, so they wouldn't have a problem with it.
Right.
Okay. All right, what's our next thing?
then we go to a series of conversations from 115 through 117, another conversation with Free Juju. This is the one where they say something about killing someone, and we do feel that that is overly prejudicial to be coming in.
So, Your Honor, this is the conversation I mixed up with the first one where Free Juju says, these are the type of people you let be slime. And in Instagram, you can send photos and so in this thread, it appears that he sends a photo of someone, like referencing. And then in response, Mr. Ryan at the bottom of page 1115, he says he says basically these are the people you let be 2-7. I think he's talking about blood gang because 2 is a B and 7 is G, 7th letter of the alphabet. Okay. And then so they're kind of going back and forth. And then when you follow just Free Juju and Ryan, that's why I highlighted because it does get hard to follow. On page 1116, this after Mr. Ryan after this Free Juju says, hey, this is who you let be slime, and then Mr. Ryan kind of shoots back, this is who you let be blood gang. And then he responds, he says, well, he's not official, but he says he'd be in 250. And I think when he's 250, Cleveland is a location. And then Mr. Ryan basically says that's not true. It's a slang term cap, as in that's just not accurate. And then the very last top of 117, Mr. Ryan to this same person, it says basically like that shit's lame because you know he doesn't like be over at 250 Cleveland. What do you want me to do? Kill him? And again, this is those two conversations which were separate are distinguishing people who are slime and are not. And someone who is claiming that and they are not officially a part of that gang is a serious problem. 2 fellow gang members is the state's position. And that's why we wanted to include this. Okay. And yes, Your Honor.
All right. So I understand the objection, but the probativity is not substantially outweighed by any undue prejudice. Okay, what's our next one?
Leave 11:55, 59. '55 and 59 are more kind of gun back and forth.
Your Honor, the state will not, on 11, I'm double checking because we get close. We're in February 12th and the murder is February 23rd, so these conversations start to have multiple purposes. Okay. But long story short, the state initially highlighted this with talking about revolvers. So the state will not be introducing 11:55.
Okay.
And then I'm reading 11:59 to make sure, and that's just a follow-on of that conversation. So the state will not introduce either of these.
Okay.
Sorry, Judge. The highlights on here, I'm not sure of the relevance on page 1172.
Okay.
The highlighted conversation.
Does that pick up anywhere after that?
Your Honor, 1172, and I missed the highlight here. It is, again, the Scarface Instagram and Mr. Ryan texting back and forth. So I meant to text. This is included for, and it continues to 1173, where the Scarface Instagram says he is messing with Mr. Ryan slat. We're locked in, little brother. And then he ends up saying, you know, hit HML, hit my line whenever you need me. And then Mr. Ryan says, for sure. So 1172 is just the start of that conversation. And, that they start out talking about some type of suit or clothing that,
All right,
They
that
bought.
doesn't seem particularly relevant.
yes, Your Honor. So can we not, or the state will not use 1172. The state would like to use 1173.
Hadn't you already established their relationship?
Well, Your Honor, the first message was, which is the first evidence that's been introduced or discussed about either Demekion Garlington or Mr. Stillwell and Mr. Ryan.
Okay.
And this is showing and he's using SLAT. He's saying, I'm messing with you, SLAT. We're locked in. Hit my line whenever you need me.
So this is actually Garling.
That's the state's understanding, Your Honor.
Okay.
Okay.
All right, then that's admissible.
Excuse me, Your Honor.
Yes, sir.
May we take a short bathroom break?
Yeah, it seems, I don't know how much longer we have on this one, but yeah, that'll be fine. Let's take a quick break.
Hey everybody, thank you so much for watching our coverage of the Young Thug trial. Now I want to take a quick second and I want to tell you about this stream's awesome sponsor, Upside. So what's Upside? Upside is a free app that gets you cash back on daily essentials like gas and groceries. So when I go to pump my gas, I can use the Upside app and get cash back. Real cash back. It's money that appears in your Upside app that you can transfer straight into your bank account. So once you have the Upside app, you claim an offer for whatever you're buying on Upside. You pay as usual using a debit or credit card. You follow the steps on the app and you get paid. And as you saw me just do, you can use Upside at places like Shell, Exxon, Mobil, 7-Eleven, Taco Bell. That's just to name a few, by the way. There are so many more. So to find out how much you could earn, click the link in the description to download Upside or scan the QR code on screen and use our promo code LCLive and you'll get an extra 25 cents back on every gallon on your first tank of gas. That's promo code LCLive for an extra 25 cents back on your first gallon of gas.
maybe 5 minutes, we might be able to make some progress
Okay.
ourselves on the next. We have this 100 and something pages of Mr. Ryan and another however many page document. Another 17 pages. We may be able to, based on what we talked about, make some progress before bringing it to the court. If we can, maybe 10 minutes.
Yeah, that'd be fine. Do y'all want to do that? Do we want to just skip ahead to something else, or I'm confused?
That doesn't matter.
And y'all could do that over the lunch break?
That's fine.
Okay, because we only have so many hours of court time.
That's fine.
All right. So what should we move to? Because I definitely, if y'all can come to agreement or narrow down, that's wonderful. But if there are some things that we need to discuss anyway, let's just move on to
We need
those.
to finish up the document that we're on.
Okay.
We'll skip another one of the documents and move to a different.
All right. Sounds like a plan. Okay. So I think our next thing was going to be 1177 is where we stopped. Any objection to that?
No.
All right, so do you know where the next one you have objection to is?
Next one is going to be.
Are y'all withdrawing 1202 since it appears to only
That
have?
was our next objection.
Yes, we'll withdraw
right.
1202.
All right, then,
And then we go up to 1169. Excuse me, 1369.
okay,
Where we have somebody else telling our client that Bali, that's the co-defendant, or co-defendant on the murder case and on this case, is locked up. And that, I believe, to the next few pages in here are other people telling Mr. Ryan that things are going on, people are looking for you, stay safe, things like that.
right.
They're not Mr. Ryan speaking.
Okay,
Your Honor, this portion, and I'll start with 1369. It is at the very bottom where the co-defendant Blaylock on this murder's nickname is Bali. And so Snake Life messages Mr. Ryan.
all right, what date is this?
This is 3 days after the murder, so
Okay.
February 26th.
All right.
And he says, Slime, Bali's locked up for that shit. And then the next time that they message Snake Life and Mr. Ryan is on page 1371, where Mr. Ryan says that's crazy. Like, he doesn't respond. What are you talking about? What me and Bali did, or what, and this is 3 days after the murder. And then, because you have to kind of take, in my mind, each thread, because what also.
Y'all may want to
Your Honor.
highlight the different threads in different colors so it's
Yes, Your Honor.
clear.
Yes, Your
This
Honor.
is one conversation, here's another one. Okay,
The next one is this Instagram handle of DeAndre Smith.
all right, so is that the extent of that conversation then?
And then it goes further on 1371 at the bottom where Snake Life, the same person, says it's a warrant out
Okay.
for you, Slime.
All right. Okay. And that's the extent of that conversation then, is that right?
Yes, Your Honor, but it concludes with a video. In Instagram, you can see a video call event. You
Okay.
don't know how long
All right,
or what
and
was.
are y'all, is that highlighted, or are y'all going to highlight that?
Yes, Your Honor.
In a color that is unique to the two of them?
Yes, Your
Okay.
Honor.
All right, so that's relevant and appears to not just be a one-sided conversation. All right, so let's go back up to whatever the next thing is. So-
Yes, Your Honor. On 1370, you have DeAndre Smith, who
Saying, hit me up and stay low.
Correct.
And then 911.
Correct.
And then what happens?
There's a video call at the bottom of 1370 between Mr. Ryan and DeAndre
Okay.
Smith.
All right. So that one would be the same ruling. And then do we have a third thing going on here, or?
The state, I have highlighted a message from Dirty Stick that says be safe. The state would not be using that, so I'm going to remove that highlight.
All right. Thank you.
Judge, I guess just backing up the messages which are one-sided with DeAndre Smith. I guess I think that's what it is. It is one-sided. Not. I don't believe there's any response from Mr. Ryan.
Well, what Mr. Atkins just said was there's a video call after that. Video call event.
I could be wrong. I don't think it shows whether that video call is answered. I think there's an attempt to make one. I could be corrected, but I don't think there's anything which shows that the video call did actually take place or that it was answered.
Your Honor, I don't believe that that is ever captured in Instagram records. Like, it shows a video call event and nothing more, is my understanding from having reviewed other Instagram records, that that's how Instagram captures it. It's not like a call detail record where it says like call completed, or that's all you're going to get, which can be argued, I believe, by, like when we introduce this, that could be crossed if you don't know if they actually spoke, but it's the state.
Okay.
So
I mean, I think it's even though, all right, yes, so but you will highlight the video call event as well.
yes, Your Honor.
Okay. All right, I'm going to permit that. So what's our next thing?
I believe there's an additional I'm sorry, Mr. Atkins, did you say you were going to take out the other conversation in 1371?
Okay. From 1K Dirty Stick?
Thank you.
Yeah, that's what he said. All right, so where do we go next?
I believe 1372 and 1372, Judge, I believe is, again, a one-sided from ESPN self-made, telling Mr. Ryan, stay where you are, don't go to the house, and there's no response, I don't think, from Mr. Ryan. So it's just hearsay, and we don't know if there was an effect on listener.
Your Honor, I was trying to, and I may have not included this. I can't find where I have Mr. Ryan's response to this in the thread. I may, when we have this break, look up the original thread to see if he ever responds to that.
Okay. So you can get back to us on that one.
Yes, Your Honor.
All right. Then what would be next?
Your Honor, the next few pages I don't know if there was anything on 1373.
1373. It doesn't look like it. So would 1373 and 1374 is, I mean, they're in here, but.
Yes, Your Honor. So 1373, there's more video calls between that DeAndre Smith and Mr. Ryan.
Okay. So they're not highlighted, but you would highlight them?
Yes, Your Honor. I intended to. I missed some things when I was going through, or forgot to highlight. That was why I included that one.
All right. And it continues on to 1374 also? Or Is there a reason 1374 is in there?
So 1374, it partially continues. So what ends up, there's a new thread as well where, and I'll highlight this, it's kind of the totality of it where Mr. Ryan text or messages through Instagram, DYN finesse, and says, hey, this is Little Rod, can you help me get a lawyer? And then he's messaging again another person saying, hey, this is Little Rod, can you help me get a lawyer? And then he messages back to that DeAndre Smith who he's been video calling with, and he says, this is Little Rod, can you help me with a lawyer? So it's after all these people are saying, hey, there's a warrant out for your arrest, and some of these individuals, like for example, the DYN finesse, there's other photos with Mr. Ryan and that individual, and so that was why the state included this, was after all of this notification about the thing that him and Bali, hey, Bali got locked up for that stuff. He speaks to all these people, and then he's reaching out to various people to try to get a lawyer seconds later.
Okay.
Judge, I just don't think it's appropriate that the state is trying to use against him asking for
His
a
constitutional
lawyer.
right to have a lawyer, agreed.
Yes.
I'm going to exclude that if that's all that's for.
Yeah. Understood, Your Honor. There was more connection, but I'm not articulating it well in terms of these individuals and their connection, but understand the court's ruling will not use this.
Okay.
Okay, so 1374 is out.
And I think, well, they're right. So that would be 1374 through 13, what? Is that it? Just 1374 then?
Yes, Your Honor.
Okay.
In terms
All
of that
And then
topic.
so 1376 then is something new. Is that right? Okay. And what is there an objection to that?
I'm not sure, Judge, on if the state, at least this one, is trying to assert that this is 1376, if this is Mr. Garlington, or they're trying to attribute this to Mr. Stillwell.
We can withdraw this. Okay. Withdraw. All right. 35, I don't see any more highlights.
I believe, Judge, and I will double check with Mr. Atkins, this is a block of conversations largely between other implicated parties who we would have no objection or no valid objection to saying they shouldn't come in, and also will be duplicative in a second document that we will discuss with the state. So
Okay.
the balance of this.
We'll just circle back to.
Correct.
If needed. Okay.
I agree with Ms.
So then are we done with this document?
We are.
For now? Okay. All right. So where else should we then focus?
We had objections to the document, which is Mr. Blaylock's Instagram. It's in that same Dropbox folder.
Okay. Can y'all point me to?
Yes, Your Honor. It's Blaylock Instagram reduced.
Yes, got it. And it's like 109.8 megabytes. Is it that one? It's a PDF?
Yes, Your Honor.
Okay.
Yes.
All right. And Blaylock was his co-defendant on this case, right?
Correct.
All right.
Yes, Your Honor.
All right. And,
also a defendant in this.
right.
Right.
Yeah. Just a severed defendant. Yeah. Okay. All right. I have that open. So if y'all want to give me the page references where there is objection.
Judge, I believe, so we have no objection to the first photo, 89. I believe almost, if not all of these pages of Mr. Blaylock, oh, I'm sorry, there's some photos that I didn't see. Page 91, this is relevance. I don't think we know who the other person in this photo is, so outside of that, we have just Mr. Blaylock.
Okay.
Your Honor, I'm pulling up right now this document. So, Your Honor, this specific photograph, that Snake Life handle where he puts right hand, messages Ryan, what I wanted to go back and check was if some of the admitted threads we introduced, because the state wants to show that they have, interact with the same people and also each other. And so the purpose of this was that Snake Life is in Mr. Ryan's Instagram. I just want to double check with what we've just went through, if it's still included.
Okay, all right. So if the @SnakeLife handle is one of the things that came in as a communication with Mr. Ryan, you want to show that whoever this person is @SnakeLife also hangs out with Mr. Blaylock.
Correct, Your Honor.
Okay.
So Judge, the remainder of this document, I have the same notes on that there are, again, we don't have a good argument or any valid argument that conversations between Mr. Blaylock and other implicated parties in the murder, Tahira Hartsfield, we have no objection to those back and forth between Mr. Blaylock and Ms. Hartsfield.
Okay.
Conversations with Mr. Ryan. I believe everything else in here is Mr. Blaylock, who's obviously not sitting here with us, and unknown people. So I don't see how those are anything except rank hearsay and would not be admissible here. Against Mr. Blaylock, sure, but he's not here.
So, Your Honor, and just to orient the court of basically part of these Instagram records were part of just the murder itself in terms of who's messaging who. And I say that in terms of there were some other females involved and they were messaging both the victim's friends, Mr. Ryan, Mr. Blaylock. And so they're kind of in their own unique category. And then the other messages in this Instagram are tethered to count one, the RICO, and the Street Gang Act charges. And so the state, with what is not covered in messages between the other people involved the night of the murder or Mr. Ryan, is for, and I'll explain what I'm, co-conspirator hearsay in furtherance of the criminal street gang. So, and I don't know where,
If I could pause one moment and add to that, Mr. Ryan and Mr. Blaylock are not charged with participation in criminal street gang activity, just the RICO. So for them, it doesn't really matter whether it's a gang or not.
Your Honor, count one RICO is
RICO by being a gang, basically, right?
correct, Your Honor. So yes. So the state still, it is important to prove and very relevant YSL, the criminal street gang, criminal enterprise, I should say.
Yeah. Okay, so I think if the response to the hearsay objection is that it would come in under the co-conspirator exception, then I would need to kind of look at what we're talking about.
Yes, Your Honor.
Right.
I agree. And so I'm trying to find the first message that doesn't involve.
Okay.
Yeah.
Page 238.
And if does the state, if the defense wants to, does the
Shall we
court?
get together on this one also? Would that be more helpful?
I think we just disagree. The state says these are co-conspirator. They come in and we say we have no idea who this.
Okay, well then, if you can point me to which ones we're talking about in this however many page document this is, then I can maybe make a ruling.
The first one is going to be page 224.
Okay.
Nothing's highlighted. I don't know what. I don't know.
What is 224?
So
Are y'all ready on this, or do you need to?
No,
look? Okay.
I'm ready, Your Honor.
All right.
The 224, I believe, I know why. So we don't need this. He puts his phone number in,
Okay,
224, but.
It's out. What's next?
236, the next page.
Okay.
So his Instagram changes, but for the court's awareness, one King DO1 is Mr. Blaylock's Instagram. So at the bottom, when BB Infredo says, I was just locked up with you. We just got back from YDC, Youth Detention Center, though I was ROLAC. And so we're going to cover a number of things in terms of conversations about sex, money, murder, and conversations about YSL. And so Mr. Blaylock, they go back and forth, and Mr. Blaylock at the bottom of page 238 says, how do you know me? I'm murder as well, like saying I'm sex, money, murder. And then they explain about meeting each other, playing basketball in YDC, et cetera. And then he responds, Mr. Blaylock says, but I did not know you were ROLAC till now. And then he says, he asked if someone honcho is rocking right.
He asked if someone's honcho?
His name is Huncho, is still rocking right. And then Mr. Blaylock responds, yeah, he's still ROLAC, he's G. And so that particular back and forth is specifically about, which, in the indictment it says YSL, criminal street gang, a subset of sex, money, murder. Verifying or checking in conversations between two people who within this text thread are identifying themselves with sex, money, murder, street gang. They're asking if the specific person is still rocking right. These are private Instagram conversations, and for the jury with Mr. Ryan and this overt act, Blaylock and Ryan's gang affiliation in connection with one another is relevant. And so the state is, with these in PDF of Blaylock, believes that this conversation about information about sex, money, murder, and other members, and when he's saying is someone still rocking right, like basically is he still in good graces, is he still, and they're confirming and validating with one another. Those kind of conversations happen frequently in a street gang and are necessary to know who's in the gang, who's not, and to, so this specific thread is specifically about the sex, money, murder conversation. And that goes up to page 239. There's a separate, 276 is a separate conversation.
Okay.
And that would be very good evidence against Mr. Blaylock, who's not here.
So, Your Honor, in this trial itself, there's been conversations from APD gang detectives about Pete Rolak, sex, money, murder, the two pistols, and there's been a plethora of both state questions and cross-examination all about that. So having a private conversation with Blaylock, who the state believes the evidence will show, committed this act with Mr. Ryan, and are YSL members, and in, which is a subset of the sex, money, murder, criminal street gang as well. This is relevant because here in this thread, he is using and saying things privately with another individual he was locked up with in YDC. And even though Blaylock is not in this trial, it's relevant for the jury to understand that this co-defendant who's just severed, he would be in this trial, has the same gang affiliation and both YSL and sex, money, murder as Mr. Ryan, which has also been attributed to other defendants in this courtroom through testimony by APD gang detectives or social media. And so that's why the state wanted to include this specific portion. And specifically feels that because they're discussing criminal street gang, it furthers the criminal street gang because gang members need to be able to recognize one another and know who else is a member. It's not specifically about YSL, but it's about sex, money, murder, which has been, so that's the state's on this specific thread.
There are a lot of relevant things. They're not necessarily admissible.
So the thing that is causing me some pause with this is that it's just this one conversation, right? And you're saying it should come in under the co-conspirator exception, and yet doesn't there need to be something outside of the conversation that establishes this other person's participation?
So, Your Honor, it's whichever individual statement is being utilized as an exception to the co-conspirator hearsay. For example, anything that Blaylock states. The state, to the court's point, anything that Fredo would say, the state's position is, and again, it is kind of like line by line, because I'm not going to be presenting other evidence outside of this text thread about Fredo and their gang affiliation. So the
Right.
state is relying on evidence which is in this Instagram or other evidence in the trial about Blaylock's gang affiliation, his
Right,
statements,
yeah,
and the
Blaylock,
effect on him.
not so much, but
Yes,
how
Your
about
Honor.
the other person?
So I will not, there's no other evidence that the state will be presenting or can proffer about specifically Fredo's sex, money, murder gang affiliation.
Okay, then how does this come in, or how does his part of this conversation come in?
Your Honor, the state would view what Fredo is stating is necessary to complete his response. It's like, for example, on page 239, it's Fredo who says, he asked if this individual, Huncho, is still rocking right. I don't know who that individual is. The state's not trying to assert whether he is or is not, but Mr. Blaylock responds, yes, he's still Rolac. He's still sex, money, murder. He's G. And so whether you could insert any name for Huncho, it could be Fred, John, that same response by Blaylock of saying, yes, that person you're talking about, he's still sex, money, murder. That's why the state wanted to introduce this thread. And so Fredo's responses, the state believes, are necessary for context to Blaylock responding back. So have either a non-hearsay purpose or kind of necessary to complete Blaylock's response. Because if you just introduce Blaylock saying, yes, he's still Rolac, he G, you don't know what he's responding to. And the state for, just page 239, that, exchange, I think, is the best example of how the state, to get through hearsay, co-conspirator statement of Blaylock, and context to Blaylock's responses for Fredo on this specific text thread.
So what do you actually need of these 3 pages?
So, Your Honor, I think 239 is one of the more important of this specific thread, and the state could do without, or could, the state does not have to use 236.
Okay.
And then 238 at the bottom, where Mr. Blaylock says, how did you know I'm murder, sex, money, murder? And then would include 239, where that bottom portion, where he's asking if a specific person is still rocking right.
Okay, so bottom of 238 is Mr. Ryan saying,
Mr. Blaylock, Your Honor.
I'm sorry, Mr. Blaylock saying, how you know me, you know I'm murder.
Yes, Your Honor.
And then the response is, but I didn't know you was Rolac till now?
Correct, and they're somewhat interchangeable in terms of Pete Rolac founded Sex, Money, Murder, so sometimes they'll say, I'm murder, I'm Rolac, and then after that, this Fredo is asking Blaylock if a specific person is still rocking right, and Blaylock responds, yes, he's still Rolac.
And he's Huncho. So it is that Mr. Blaylock can affirm someone else's gang affiliation?
And specifically Sex, Money, Murder, yes, Your Honor.
Because he is also.
Correct, Your Honor.
Is your point.
Yes, Your Honor.
Okay. Yeah, I mean, I guess if the only thing. So could you do without the, but I didn't know you was, well, I guess not, because that's your whole point.
Judge, I still don't understand how we're getting around to hearsay exceptions, or hearsay prohibitions here.
And
Well, you don't understand for Frida or for Blaylock?
We don't have Blaylock here right now. I understand he's charged.
He's a.
For Frito. No, I'm sorry, for Frito, yes.
Yeah, and I think that what the state's response is that you need both sides of the conversation to understand what is being offered against, what's being offered with regard to what Blaylock is saying, which is, I mean.
Judge, given the speculative probative value trying to piece together what this is saying on both sides, we would ask it be included under 403.
Frankly, I'm trying to piece together all the different abbreviations.
Right.
Which I guess young people know, but I'm not young. It's all relative. Yeah, I think it might be better to just exclude this.
yes, Your Honor.
All right, so then our next one is
276.
276. Okay.
Now here, Blaylock says, he's talking to someone new. And
Okay.
he says, why the hell you didn't say you were slime when we were locked up? He's talking to someone else he was locked up with at YDC.
Okay.
And then the person responds, I didn't know you were slime. I just thought you were blood slat. And then Blaylock responds, I'm an OG in that slime shit.
Is there any objection to that?
Don't believe so, Judge.
Okay, where's the next one that we have objection to?
Believe the next one is going to be Judge, I guess I'm trying to make sure, are we saying anything that Mr. Blaylock says comes in?
I mean, in terms of him being a co-conspirator.
Right, well, he's a co-conspirator, but it has to be a conversation between two co-conspirators.
Well, you're going to need to point me to whatever the next objection is, because I'm not going to know what conversation we're talking about otherwise.
The next one is going to be 292 with hot shit
Okay.
is the name.
And so, Your Honor, on 292, Blaylock's nickname is Biley. So that Instagram handle that ends in LIJRR says, hey, Biley. And then he says, a young person who stole the Mustang from CEP. He's trying to orient Biley to who he's talking about, to Blaylock. He says, he's trying to put me in slime, but he said, I got to get put in by you. And he's talking about getting put in the gang, the street gang. And when he says, or go to 250, he's talking about 250 Cleveland. So if you follow this a little further, they continue speaking, and Blaylock says he's going to have to give him money, $25, And then he responds, I'm getting in the fire, right? And Blaylock, and he says, I'm trying to be real right. Again, that was that earlier, real right means like I'm trying to be like official blood. And in this context, official YSL. I didn't want anyone coming up to me talking about I'm not real slime and shit. And then Blaylock responds, oh, you're going to be real slime. On slime, you will be. And then the person says, all right, say no more, S&M, saying, say no more. I am on Cleveland. Where are you at? I'm on Cleveland right now. And Blaylock says, I'm on Cleveland. So this is in furtherance of the YSL criminal street gang because Blaylock is about to put this person in the gang. And he says, and the guy's like, wants to make sure he's officially a member of YSL, and Blaylock assures him, you're going to be real on slime, you will be. And then they talk about meeting up to complete this conversation in person or, do what they need to do to get this guy in the gang.
Okay. And so once again, how is what the other person is saying?
So, Your Honor, to me, it completes the context of this thread. So and looking at this line by line in 292, the first thing he says is, hey, Bali. So whether he means hello or goodbye, that statement is neither here nor there. And then he's orienting Blaylock. I don't know who he's talking about, the person who stole the Mustang from CV. Because Blaylock right above that says, who is this? And so he orients him to a person. He might as well just take that phrase as a name. Instead of saying, John, it's this person who stole the Mustang from this other person. And he says, that person is trying to put me in slime, but said I got to get put in by you or go to 250 Cleveland. And so for the jury to understand why Blaylock responds, oh, you're going to have to give me $25. And then they continue speaking about, and for Blaylock to say, you're going to be real on slime, you is. This whole conversation is about this individual trying to officially become a part of YSL. And so the state feels that Blaylock's statements are in furtherance of the gang, which needs members and continuously recruits or gets new members. And everything that this other individual is saying is necessary for Blaylock's co-conspirator statements to be understood. The state's not arguing that this LILJRR is a part of YSL because the whole point of this conversation is to get in the gang. And so the state feels that in terms of true hearsay, Blaylock's is in furtherance of the gang because he has to speak with, they have to meet up, and he's literally saying, I'm going to put you in officially into the gang. And what this other person says, whether he, whoever this person is that they're trying to orient about stole the Mustang, or when this person is asking him, I'm trying to get put in slime, but he said, I got to get put in by you. Whether that other person said that or not, the fact that orients Blaylock's responses, which again are to further the gang by getting a new member that's properly verified by Blaylock.
I might have to come back to that one. I'm going to have to give that one some thought.
Yes, Your Honor. The state is not going to use 338, which is PDF page 15, Instagram page 338.
Okay.
On 342, Blaylock is asking Snake Life Maniac, which is a double reference to both YSL with the snake and then, when he's crossing out the C, put an X. Nonetheless, he says, "Are you slime?" And the person responds, "Yes." Like, "Who are you?" He says, "I'm Little Bolly, I'm slime and murder. I'm YSL and I'm sex, money, murder." And then immediately he asked the person who stamped you in slime, who basically made you official in the street gang. And the person basically is like checking him right back and saying, "Well, who stamped? I've never seen you on the Ave," talking about Cleveland Avenue. And so they go back and forth, and then Blaylock says, "I'm on Cleveland all the time. I stay on the Avenue." And then he says, "I'm a big dog. Ask me. My name holds weight on Snake," as in like I'm higher ranking in the gang. And then this person responds, "I don't really be seeing you around." He says, "I'm Maniac, and you can ask anybody on the Avenue. My name holds weights too." And then they ask, "Who stamped you in?" And Blaylock says, "Pokey." This is the same Pokey who in the interviews of the shooting of YFN Lucci's mother were talking about Kenneth Copeland when they were at Big Boo's house and they got the call about $10,000. That's what those statements of Zachary were talking about. It's the same Pokey. And so he's saying, "I literally got stamped in the gang by Pokey." And then this guy's kind of trying to verify this because he's like, "Well, Pokey's been locked up for 6 or 7 years, so like, when did you get stamped?" And then he responds back to him, "Gorilla stamped me." And Blaylock says, "I was YL, which is Young Loyalty, rock crew, raised on Cleveland crew." And they continue speaking, and the guy says, "I never met the young rock crew. I just know Big Eye and the rest of them." And then Blaylock kind of verifies, he says, "I be with twin of them, like I'm basically with them." So this whole conversation is them checking one another for, are you legitimately YSL, etc., by the way that they're speaking. And so they list who stamped them in the gang and, mention kind of how they knew each other. And so this whole conversation is, again, it's the larger conspiracy of the criminal street gang. Doesn't have to be tethered to, in this specific context, is also part and parcel of the RICO criminal enterprise. They're kind of one and the same. The state's alleging and putting forth that this criminal enterprise is YSL, which is a street gang and a criminal enterprise. So this whole conversation is in furtherance of the criminal street gang because, again, you have to have a way to verify and check who's a member. Because if someone is a member, you can trust them more. If they're not, you need to know that. And if someone's falsely claiming, that is a serious problem. And so this whole conversation furthers the criminal street gang enterprise because they are trying to verify one another. And is also Blaylock stating all of these things and actively claiming his gang affiliation, which, no, being a member of a gang in and of itself is not a crime, but in contexts like the one we're in, these kind of conversations, also go against his own interest when he gets charged later on in this exact RICO. So for those reasons, the state feels that this conversation is co-conspirator hearsay for both parties because of the way that they're using specifically YSL gang identifying language and verifying one another, which that kind of conversation is a conversation that furthers the gang. And so that's the state's position for this specific conversation of why it is not hearsay.
Judge, I understand all of that this conversation would establish this conversation. The co-conspirator hearsay exception, there has to be something besides this conversation. And we don't have anything.
Yeah, so I've got a question about that. And can other circumstances that are can other evidence corroborative of what is going on in this conversation be what establishes the existence of the co-conspiracy? I mean, the fact that they are talking about things that we know from other evidence, is gang related and is specific to this gang and things like that.
Your Honor, the answer is yes, in terms of For one, if you started a trial with a co-conspirator, pre-trial you have a motion in limine, and you say the state wants to introduce this 2 gang members discussing, just think of the most perfect example of something that would fall into 801 D2E. You could introduce that statement as the first piece of evidence with the proffer to the court that this evidence will come in to prove it. At this stage of the trial, in terms of October 11th, 2024, the state believes that there is an ample amount of evidence that YSL is a criminal street gang. That evidence of that, and the reason that's so important to the court's question is once that evidence is either established or you proffer to a court and ultimately before the trial resumes is in evidence, then all of these statements, if they further that conspiracy, then it would satisfy 801
I mean, I think there is other evidence in this case that establishes that both of these people would be co-conspirators. So I am going to let this one in.
Judge, I guess I don't understand what the other evidence.
Well, I mean, like just for example, the focus on Cleveland and him already knowing that that's important, and the person, Gorilla, having been the one who stamped him, things like that.
Right, but the requirement is that it be outside of those statements.
Right, right. No, well, right, which is what I'm asking then is, it's not just their conversation together. We already know from other things that a focus on Cleveland Avenue and a person named Gorilla are related to and important to this alleged gang. And that is outside of this conversation. And so things within this conversation.
I don't think that's.
Okay.
If I
So
can point you to a case.
Yes, because I would think, yeah, I need to know
Yes.
the answer to that.
I'm taking a look, Judge, at Williams versus State, which is 293 Georgia 750 from 2013. And we are talking about co-conspirator statements. The requirement is a prima facie case. The rule says prior to introduction of the statements. That case held it didn't have to be literally prior, it just had to be at some point during the trial. But it states, furthermore, conspiracy may be shown by direct proof or by an inference deduced from acts and conduct. And the content of this statement is neither act nor conduct. The continuation, which discloses a common design to act in concert for the accomplishment of the unlawful purpose, common design or purpose, may be shown by direct or circumstantial evidence. But I think by that, there has to be act or conduct, not just the content of this statement.
Your Honor, if I may?
Yeah.
So I wrote this, and so the case citations, I'm looking at my motion that was filed July 26, 2024, which is the state's response in opposition to defendant Stilwell's motion for reconsideration. This is straight from Kemp v. State, a case 5 years afterwards, and is a seminal case. You need to look at gang conspiracy cases to fully appreciate the 801 D2E exception in the context of a street gang RICO.
The site, please.
And so,
What's the site?
So,
Kemp?
Kemp v. State is 303 Georgia 385 392 2018. All of the cases that I'm going to be citing are in this e-filed motion on July 26 at 11:19 p.m. With all that said, starting from the basics, 801 D2E. 801 D2E mandates that the hearsay prescriptions do not apply to a statement by a co-conspirator of a party during the course and in furtherance of the conspiracy. So going on a little further, the state, and this is straight from Kemp, Penn site 392, the state is required to show by a preponderance of the evidence that, number one, a conspiracy existed, which in this case is the YSL criminal street gang enterprise. Number two, the conspiracy included the declarant and the defendant against whom the state is offered, which the state, again, this is Blaylock, this individual he's talking about, and the 6 defendants in this trial. They all have to be a part of the same street gang
Nobody
conspiracy.
has a problem with Blaylock being considered a co-conspirator.
Yes, Your Honor.
It's
this other person and how that can be established.
So
And maybe you were getting to that, but.
Yes, Your Honor. And so I will find, I'm trying to find the case site on this specific, if the court gives me one brief second.
Sure.
Sorry, Mr. Atkins, the pin site, please.
Pin site was 392 for,
Thank you.
But I'm not sure it answers the question we're discussing right now. Well, maybe it does, I don't know.
well, Your Honor, I would, so I was trying to find my understanding
Okay,
is if you had a statement, you're not restricted to the four corners of, you just have to prove to the court by a preponderance that the person making this statement, which in this context is snake life maniac.
right.
You can use the four walls, so to speak, of this Instagram thread. You could also use other evidence if the state had it. The court just has to find that snake life maniac is, to a preponderance, a member of the same criminal street gang conspiracy as Blaylock and the defendants, or the argument the state makes in terms of if you believe Blaylock's statements further the street gang, and there was some either context on Blaylock or non-hearsay purpose. That's how the state frames this specific issue of, and the state does believe that this is one of those unique circumstances where, because of exactly and specifically the way that they are communicating in these pages we just walked through, that to the 51% for lack, it's not numeric, but in preponderance, it's pretty close. This court can make a finding that based on the way that they are discussing, and this is where the other evidence at trial that I'm not going to run through all right now, but the evidence of APD gang detectives, the other identifiers of YSL criminal street gang that this individual is using, his handle itself is Snake Life, coupled with, again, none of these are dispositive, but I believe that to a preponderance through this conversation, the court could find that this individual is a part of the same conspiracy as Blaylock and the defendants, which is the YSL criminal street gang enterprise. That is the state's
And I'm just trying
argument.
to sort out if the something outside of the four walls can be, like the two examples that I already mentioned, that kind of corroboration is sufficient, which I would think it is. So, and frankly, you just also mentioned his Instagram handle, which might be enough right there. All right, so I am going to rule this admissible. However, Ms. Abbasi, if you come up with something that answers the inquiry differently, then please let me know and I'll reconsider the ruling.
Okay, and
All right.
I'm sorry, the inquiry would be if there's something else.
If the something outside of the conversation can be
Part of the,
something like
what his name was, or
what his name was, or, that he has what seems to be inside knowledge that we already know from other evidence is significant to this alleged gang.
Give me one moment to write it down so I don't bring you a bunch of irrelevant case law.
Okay.
Okay, thank you.
Thank you.
All right, so sorry to take us down a detour, but it's fairly important, so I think it was a legitimate detour. All right.
Maybe a matter that we should take a look at before going further, because that is literally the same argument and basis up through page 30, or page 34 of the document, and we don't have an objection to the remainder, which is co-defendants.
Okay.
Otherwise, we're going to just keep arguing the same thing for the next 20
All
minutes.
right, so we'll need to know the answer.
Yes.
Okay. All right, so where should we move next?
You can do the videos, Your Honor.
All right.
And Mr. Atkins, if you could say like the last 4 of the videos that you're going to play, so I can follow along. Thank you.
Is there a particular, Your Honor, could I have just 30 seconds with defense counsel? We can see where it makes the most sense to start. Your Honor, we're going to start, and I hope the court's Dropbox is oriented the same, but what I classify as the bottom, but I'll give, they're titled different ways. They don't all have, they're not all numbered 1 through completion, but there is there's a video from 12, it's titled 12/20/2021 video, and it's 54 seconds.
Okay.
I don't have an objection to that one.
Okay.
There is another one with, it's 2/8. It's, some of these do have numbers. It starts with 28. It says videos 18, and it has, if you can read the letters, free big as the caption. It's 15 seconds.
One more time, Mr.
All right, I only see one that starts 28 videos and then underscore 1888 something or another. Is that the one?
Yes, Your Honor, that is correct.
Y'all got it?
No, which one was that? I'm sorry.
So it is in 4719.
I can play it for the court.
Is there an objection?
Yes, could you play it for the court? I'm sorry.
I'm frankly, I am not logged into Zoom. I'll just watch it on, well, although, does the audio matter? Isn't this already in?
No, it's not, Your Honor.
Does the audio matter? Because I don't have my audio on.
So this I'll be objecting to relevance?
Yes, the audio matters.
It does.
Okay.
It says peace and blessings, which isn't a bad thing.
So you want us to play or you?
Just, if I can get my speakers. Ooh, that's loud. All right, what's the objection?
Relevance?
Your Honor, this is This is Mr. Darius Ford, Your Honor. So this shows a video with Mr. Ryan and Mr. Darius Ford, who we'll talk about further. He'll come in probably in the next couple of weeks. He was the individual who was killed right after Mr. Rayshawn Bennett was stabbed, not right after, but a few weeks after Mr. Rayshawn Bennett was stabbed in the Fulton County Jail. And we believe that, or the state's theory is that Mr. Ford and Mr. McMillan were killed as a retaliation of that stabbing. And so this shows the association with that individual. And I believe within the post he says YSL as well, social establishment there.
And who's going to identify him?
Oh, I'm sorry. Who will identify Mr. Ford?
Yeah, that this is the person in the video?
Investigative Retail.
All right. It's overruled.
And we also have a picture of him with another YSL co-defendant, Durante Beebe, that we entered.
Sorry,
You also need to hold that mic closer to you.
the co-defendant.
And
on.
turn it on.
I believe it's on.
Then hold it closer to you.
Okay. I'm sorry. Mr. Ford, YSL is not in the video. Mr. Ford, we believe, is a YSL member. There's also a picture of, you asked how can we identify him? We have a picture of Mr. Ford that has already been admitted with Mr. Ford and another co-conspirator, Durante Beebe.
Okay. Mr. Sharp?
So, Your Honor, my objection isn't whether this is Mr. Ford or not. My understanding is the state is saying Mr. Ford's an important part of this story because he is murdered in 2022. I understand this is a RICO case, but for the purposes of the importance of Mr. Ford and Mr. Ryan being linked, Mr. Ryan is in prison at the time of Mr. Ford's death, as well as the death that the state is claiming was payback for Mr. Ford's death.
Okay.
So, Mr. Ryan, and the reason I say that is because while I understand the state has established connections of Mr. Ford to other people, and I understand their argument for the relevance of that, I don't think that this case requires a link between Mr. Ford and Mr. Ryan as much. And my concern is obviously the prejudice and the spillover prejudice on all of us when the way of showing the link between Mr. Ford and Mr. Ryan, which I say has very limited probative value, but the video itself that shows that link involves Mr. Ryan waving a handgun around. So that's my concern.
So yours is a 403 objection. Response.
Yes, Your Honor. A part of our indictment, again, Your Honor, is that these individuals maintained armed individuals ready and willing to preserve, protect, and enhance the reputation, power, and territory of the enterprise through the use of violence. The fact that Mr. Ryan is publicly, these are public posts, toting his gun, and he is with another YSL associate, Your Honor, we believe that the probative value is not substantially outweighed by its unfair prejudice.
All right. I'm going to overrule the 403 objection. What's next? Which is our next one that is objection, that there is an objection to.
I guess is it the 12/25/2021? Is that the next one?
And what's the objection?
Cumulative?
Cumulative?
Because it's saying just Mary Brismus, changing out the.
Is this a video?
It is a video. But I
And-
believe the audio is just rapping in the background.
Okay.
Your Honor, the state for that specific video will not used that video, 12/25/2021.
Okay, so you're withdrawing that?
Yeah, I'm withdrawing, yes, Your Honor.
What's next? Do y'all know the next one you have objection to?
Sorry. I believe the last four is 8521, 29 videos. You can't see anybody that's in the vehicle. It's just a gun and a camera. And the caption on the video is a stick emoji and a star emoji. So that would be relevance, cumulative, foundation.
Your Honor, this, and Mr. Ryan is wearing a YSL chain. This is a public video where it has that snake, and you know that if the court can see, that is a probably 50-round drum in the magazine on the bottom of that gun. So it's a public display of both YSL and a fire, and Mr. Ryan using a firearm. So the state's purpose of this video is to show that public display, which is important to, one, create fear or, you know, for the game.
Got it, overruled.
They already have photos of him with guns.
Not with a gun with that kind of a attachment while wearing a YSL chain. All right, next.
The last four, 7005, 31. I guess video 31, the last four, 7005.
All right.
Cumulative, relevance.
All right.
There's the state will withdraw this specific video.
Okay. Next.
Three, 4, 5, 2, number 32. 3, 4, 5, 2.
And the objection is?
Your Honor, it's probably going to be the same, relevance, cumulative.
Is there something new in this video that hasn't already been shown?
Your Honor, I was trying to confirm when the date of this post was, where he says free little d, but I meant to have a note of that date, but the state will not introduce this. I asked grace from the court that if I find a date and someone the state believes is a YSL member, little d was incarcerated when Mr. Ryan made this post, I would ask to revisit, but no, the state will not intend to introduce this absent me readdressing it with the court.
Honestly, I think even if this is posted while Lil D's
Yes, Your Honor.
that it's cumulative.
Yes, Your Honor.
Next.
The next one is 0944, number 34. It's the same thing, cumulative, relevance.
All right, is there
Throwing
something
lights
new in this?
So this one, Your Honor, where it starts with 3-4 videos, Mr. Ryan and the other individuals in that video are all throwing up the YSL hand sign,
Okay.
which we have not discussed or introduced with going through this. So the state feels that that is unique and independent compared to what we've discussed thus far.
Could we do this one without the audio? The audio is not relevant. Is it?
No, Your Honor.
I'm asking the state.
Oh,
Thank you.
Sorry. Well,
Your
not
Honor,
for the defense. I'm sorry. It's not relevant.
I believe there actually is some at the very end. I didn't transcribe these videos, so when
Okay,
I've-
well, you can let me know.
Yes, Your Honor.
Otherwise,
I
we're going
will-
to do this one without audio. All right, why don't we break for lunch? And let's just be back at 1. Yeah.
I think you said you want to think about, I believe it's Mr. Blaylock's statement to someone else about joining the
Right.
gang. And, I'm sitting here and I don't know how that comes in. Mr. Blaylock's not a party opponent, and I'd like you to look at a case if you're going to do that. If that's okay, it's Kirkland, Kirkland versus State. It's 318, Georgia, 639. And it's a 2024 case. And it's in Division 4. And it actually cites the Kemp versus State
Okay.
case, which is what the state. And in that case, the Supreme Court makes it clear that the conspiracy must include the declarant and the defendant whom the statement is being offered against. And the court said that the trial court in that case gave a proper instruction limiting that statement only to the person who was on trial. It was co-defendants. Only to the person making the statement. Mr.
Was it a
Blaylock's-
RICO case?
It's a gang case. It's not. No, I don't. It's not a RICO
Okay,
case.
I think that might make a difference.
I don't see why that makes it a difference if we're under 24-8-803 D2, 804 D2E. I mean, that's what the state is traveling.
Okay, I'll take a look at it.
Okay. Thank you. And the same in Kemp. Kemp has the same exact language.
I take a look at both of them.
Okay. Thank you, Your Honor. Appreciate it.
And Williams. I'll look at
Judge?
all 3 of them. Yes.
How quickly do you need that additional case law, simply because my internet connection is not very cooperative?
Well, do what you can over
Okay.
the lunch break. Maybe you can find somewhere else. We've got a Wi-Fi,
Yeah.
are you joined to that?
Yeah.
Maybe you can just move somewhere else. It doesn't seem to be great in this
Sure.
courtroom, or frankly, anywhere in the courthouse. Why we can't get that fixed, I don't know, but, all right, see y'all back in an hour.
Thank you.
Hey everybody, thank you so much for watching our coverage of the Young Thug trial. Now I want to take a quick second and I want to tell you about this stream's awesome sponsor, Upside. So what's Upside? Upside is a free app that gets you cash back on daily essentials like gas and groceries. So when I go to pump my gas, I can use the Upside app and get cash back. Real cash back. It's money that appears in your Upside app that you can transfer straight into your bank account. So once you have the Upside app, you claim an offer for whatever you're buying on Upside. You pay as usual using a debit or credit card. You follow the steps on the app and you get paid. And as you saw me just do, you can use Upside at places like Shell, Exxon, Mobil, 7-Eleven, Taco Bell. That's just to name a few, by the way. There are so many more. So to find out how much you could earn, click the link in the description to download Upside or scan the QR code on screen and use our promo code LCLive and you'll get an extra 25 cents back on every gallon on your first tank of gas. That's promo code LCLive for an extra 25 cents back on your first gallon of gas.
collection of drinks up here right now. All right, did anybody want to offer any further case law on that issue we were discussing before the lunch break?
Judge, I have been looking and looking and looking. I've got some references in federal cases to staying away from bootstrapping. As far as additional case law beyond that, I actually would, I guess, go back and do a closer reading of Kirkland versus State, the case that Mr. Steele cited. It does say in that, I guess kind of most poignantly, is that the co-conspirator conversation, allegedly, in that case, needed a limiting instruction to be admitted only to that declarant.
It does not say it needed a limiting instruction.
No, it doesn't say
a
that
limiting instruction was given, and so they're saying there can't have been any error when the jury was told only consider it against this one person. But I'm not sure that that answers the question of, it does not actually say, you know, a limiting instruction was needed. So, I mean, I was just looking at that same thing, and I'm not quite sure how to, that's the holding or result we ought to be taking from that.
And, Your Honor, if the state may?
Yeah, and actually, and there was not an objection on that ground at the time.
Right.
So I'm not even sure that, like, that was the basis on which it came in. Yes, Mr. Atkins.
So, Your Honor, a key distinction is, and I was reading Kirkland over the break, is it cites Kemp, but these co-conspirator statements that the state's discussing pertain to the larger criminal street gang conspiracy. So in Kirkland, if I'm not mistaken, they are talking about a more classic criminal conspiracy to commit a crime in and of itself. So I haven't read front to back Kirkland, but that's my understanding. And so when you, and the reason I highlight that is because when you have a criminal, the Kemp and the pregnancy of Chavers, when you're talking about the larger criminal conspiracy of the criminal street gang, if the declarant making that statement and the defendants are a part of that same gang, it's basically like the equivalent of a party opponent admission is how it is, you know, if you look at 801D2E and just read it. So limiting instructions are not appropriate when, if all the defendants in a trial are under the same criminal street gang, if the court finds that statement was made by a fellow gang member or co-conspirator of the larger street gang, whatever Kirkland is to make is not, it's apples and oranges for the context of this case. I would highlight for the court that the reason the state cites Kemp and Chavers is because it's talking about the larger street gang. Like, for example, and this is from Kemp v. State, 303 Georgia 385, Penn site 393.
I'm sorry, one more time. I'm trying to keep up.
303 Georgia 385, KEMP v. State. And the holding, I mean, in subsection I, it says the trial court was authorized to conclude that Watkins' statements were made. My apologies. The trial court was authorized to conclude that Watkins' statements were made in the course of a conspiracy. The first sentence after that is Kemp and Hogan's argue that Watkins' statements were not made in the course of a conspiracy because the conspiracy ended with Gray's death. But the defendants were alleged to have been part of a larger criminal conspiracy. And then it goes on to describe that. And again, the criminal street gang conspiracy is ongoing today. And so as long as the declarant making the statement and the defendant against whom it's utilized against or being it's in furtherance of of that conspiracy, which in this case again is the YSL criminal street gang or criminal enterprise, as in count one, it applies to all. If the court deems that that statement was made by a fellow co-conspirator in that criminal street gang and furthers that street gang's purpose.
Your Honor,
Yeah.
the closest I can get, and I'm trying to go back and make sure I'm reading it, trying to compare the facts, is U.S. versus Olivia. It's a 1974 Fifth Circuit case, 497 F2D 130, pin site 132. The court is talking about that there's a lack of case law for trying to decide whether there's enough independent evidence or what constitutes. We have never stated in explicit terms that the standard to be used by a trial judge in determining the sufficiency of the evidence. I'm sorry. We have never stated in explicit terms the standard to be used by a trial judge in determining the sufficiency of the evidence other than the hearsay. We find it necessary to go through those things. In that case, what they talk about being the relevant other evidence, which in this case it was not enough and it was vital and the conviction was reversed. The evidence used against the defendant there was his presence in a crowd where drugs were sold, telephone calls between that person and another person, that the appellant was in a beige Cadillac followed by the declarant into an adjacent parking lot shortly before the drugs, testimony of an officer that someone saw him in a parking lot, him driving away, a gun in someone else's possession. I'm trying to find something closer, but all of the, not factors, but all of the components which were analyzed whether this evidence was sufficient outside of the conversation were completely independent from that conversation itself. I'm still trying to find something closer, Judge. That's as close as I've gotten.
Okay. All right, and I don't know if it might be possible to see the record in the Kirkland case and figure out, if there was
It should be easily accessible.
a ruling that at the time of the trial that, hey, this is coming in under 801 D2E.
Judge, I may be able to sit in front of Odyssey and take a look. It was one of your colleagues here on that case.
Oh, okay.
Yes.
All right. I mean, I just sort of read, and I may be wrong on it, but that the court's sort of saying there can't have been an error because of this limiter that said don't consider it against Kirkland anyway. Sort of, we don't even have an issue here. I don't know. I could be misreading it, but.
If the reason that instruction, the reason there was no error is because it wasn't used against that defendant regardless, then I guess the thrust of it is it shouldn't be used against a defendant, whether it comes in at all, whether a limiting instruction has that effect. It's not supposed to be used against the other defendant.
Yeah, but so the instruction actually was any out-of-court statement by one of the defendants on trial in this case after the alleged criminal act has ended may be considered only against the person who made the statement, and only if you find it was freely and voluntarily made or whatever, which is not relevant for our purposes. But after the alleged criminal act has ended, it's sort of, and there wasn't like a RICO charge or a gang charge or anything like that. It was just a murder. And there are these two co-defendants, and I don't know if it's saying because the alleged criminal act has ended, there can't have been
a conspiracy anymore anyway, or
I will look at the
just hard to
facts. I
tell.
know off the top of my head, cover up after the fact still is included, even though that will have. Judge, I'll try to get some more specific information.
Okay.
I don't want to guess and speculate.
Yeah.
I'll try and actually find
Okay.
the facts.
All right. Anyway, which is sort of a separate issue than our other issue, which you're also going to try to find something better on. But anyway, so my ruling on that will stand unless you bring me something that.
Well, I guess that ruling will stand does mean that we would need to keep going through all of Mr. Blaylock's records.
Okay. And then, Mr. Steele, it sounded like your argument might have been, why don't you just restate your argument for me that you made just before you gave us that cite to Kirkland?
I'm going to ask the court, if it comes in, for limiting instructions, and I'm looking for proper cases for you to consider, but I believe that specific colloquy that you read, or that's at issue, I don't know how to identify except the one where someone's saying, oh yeah, I'm in the gang and I was blessed in, or whatever the words are. I don't see how that furthers the conspiracy, because it's just two people talking, hey, should I trust you or not trust you? I don't know why that is a furthering of the conspiracy. I think those are just talking about past acts, and they may be co-conspirators who don't know each other, or they may be gang members who don't know each other. So I don't know why that furthers it. But what I'm specifically looking for is Mr. Blaylock's not here, and my mind is that any statement by him should be his statement. I do understand that any act or statement of a co-conspirator to further the conspiracy is an act against everyone, even if you join the conspiracy later.
Right.
But on this particular occasion, we don't know who one person is. We're letting in, it's like the tail is pulling the dog, because we're letting the conversation from an unknown person to say, oh yeah, this has to be gang related because of what's being said, when I don't know who that other person is talking with Mr. Blaylock. And so I think that we're so turned on this issue that I'd like the court to consider it. But I'm looking for better cases for you, that if you do let it in, it's not admissible against Mr. Williams or really anybody else here.
Okay.
Because you have one person who's severed, or he pled. Your Honor, I think he pled.
Okay.
I apologize. Didn't he plead?
He did not.
Okay.
He's not.
Mr. Blaylock pled.
Anyway, that's neither here nor there.
Okay, well, he's not here.
Right.
And then we have, to me, an unknown party. If somebody knows who that is, I apologize. I don't know who that other person is. So to me, I don't see why it passes the 801 D2E test, because I don't see how, just talking about, are you in a...
Can't be in furtherance of the
Exactly.
conspiracy?
Exactly.
That's the basis of your argument?
Exactly. That's my first issue, but if it
Okay.
goes beyond that, then that's a bigger issue for us, I thought. That's why I wanted you to look at that case.
Okay, and I think that was the main reason that Mr. Atkins was citing the Kemp case to talk about the liberal, in a gang case, there's the crimes, but then there's the further conspiracy of the gang and its continuing nature. And I read Kemp to say that the Supreme Court, are very liberal on both whether something's in furtherance of the conspiracy, and there was another one that they were like, and we're also liberal on this. I don't have that one in front of me right now because I pulled up Kirkland, but Mr. Atkins, if you've got that case still up, what was the other? There were like two of the different prongs of the 801 that.
Yes, Your Honor. So.
Was the other one whether it was during the concealment phase or?
No, it was during, so.
Maybe I should just pull it back up.
Your Honor, give me 1 second, and something the court just said related to Kemp, and this is Penn site 394. it states, at this trial, there was the Gangster Disciple Street Gang.
Right.
Detectives testifies about that. It says that Watkins, who was one of the defendants, would discuss his participation in crimes with Lewis. An admitted gang member helped establish that Watkins was also associated with the gang, which is kind of similar to Blaylock, who there's other evidence is a member of the YSL street gang, like his social media, et cetera, that this other person speaks with him. That in and of itself can be used. And then they go further. They say the fact that the defendants accomplished the specific acts charged, which was the murder against Gray in this case, did not necessarily end their involvement or association with the gangster disciples, nor did the criminal street gang's purposes necessarily end with those crimes. And so I think the dispositive issue is if the court deems these statements or any statements as 801D2E, there will never be a limited instruction with the fact pattern of this case. If the court doesn't deem them admissible or says they're hearsay, well, then they're out unless there's some non-hearsay purpose. But if the court, in this case, because everyone's charged of being a part of the same conspiracy, if the court believes that a member of that same conspiracy made a statement that furthers the conspiracy, it would be applicable to all and would never have a limiting instruction.
Yeah. I mean, right now, I think that's correct, but of course, would consider further case law. But the court is instructing in Kemp that it's a liberal standard on both whether something was a statement was made in the course of a conspiracy and whether a statement was made in furtherance of a conspiracy. So, all right.
I will keep looking.
And they're kind of specifically talking about, you know, how it in the context of a gang and the cohesiveness of a gang and all of those things that the state has been arguing. And they refer to both of those as a liberal standard that we here at the trial court level are supposed to be using. Okay.
Your Honor, over the break, defense counsel and the state, we were speaking. Given the court's ruling, what the state would like to do for, I think it would be efficient if the court permits, is to, the state is looking through the remainder of the Instagram that is left with specifically Acts 79 through 81. And so we have whittled down some more, but the state would like to, if defense counsel and the court permits, give a, have a brief period of time to whittle it down further, present to the court and counsel. And if the arguments are, to Ms. Abbasi's point, they're going to be similar arguments.
Right. Okay. All right. That's fine.
Judge, my only request with that is we've been repeatedly requesting the whittled down version and we get something. And Mrs. Williams and I spend hours going through it, every single page prepared to discuss it. And then the state says, well, we'll narrow it down some more. And we do this over and over.
Well, I think they're narrowing it down some more now because some of your objections have been granted or whatever. And so they're saying, okay, well, we understand that reasoning. So from the universe that you most recently got, it'll be smaller.
If we could get a deadline of time just so we can plan on when that's due from the state.
And we can keep going through these now. I don't think it would.
No, I don't.
But, it's probably only going to help defense counsel in terms of the state's intending to reduce what we've already.
Exactly.
Tuesday, Wednesday, just.
I would think it would be before. My plan is to do it tomorrow, depending on when we get out of court today.
Okay. That would be great. So
That would
get
be
it to
great.
them before Monday.
That would be wonderful.
Okay. All right. Okay, so what are we going to look at then?
We can keep going with the videos.
Okay. So we were on number 34, ending in 0944. Is there objection to that? Oh, no, that was, we dealt with that one, and that was, the state was going to see whether there was anything significant in the audio, and otherwise, do you know the answer to that yet?
Yes, Your Honor.
Okay.
We do not have to play that video with
All
audio.
right, so that'll be without audio. All right, so what is the next one that
council has objection to.
Okay, that would be 7223, video number 35.
Okay,
And it'd be the same cumulative.
all right. And should I?
No, Your Honor, because once we went through a few
Uh-huh.
at the lunch break, and we may be withdrawing.
We just want to pull up and confirm that that's
Okay.
one of the ones.
Cause you like the gas station one, good on.
So, Your Honor, there is another video that me and D. Williams were discussing that the state would be introducing for a similar purpose. And so the state would not be arguing to introduce 35
All right,
if there's
y'all are-
another video that the state
Okay.
would,
All
that I
right,
noted.
so 35's not going to be offered. Next. Do you know which other ones aren't going to be offered?
Yes, Your Honor, and
Do Mr. Williams and Ms. Abbasi know that?
we were discussing that before we resumed.
Okay.
And what may be helpful in this case is there is a specific video that I know me and defense counsel spoke about that they're objecting to that I can play next, which begins with or ends with 1797 and starts with videos _1985.
Could the state possibly just delete the videos that are currently in the Dropbox if they're not going to play them?
Can y'all do that real
I don't know if
time
you can.
while
That would
we're
be very
in
simple,
the?
though.
I can. I'm also using this to publish for the court, but yes, I can delete. I mean, that takes
Okay,
no
go ahead
time.
and delete. I've got the Dropbox up, so if you want to get rid of the ones we're not going to need to think about.
Yes, Your Honor.
And they hopefully will disappear in real time.
Mr. Atkins, please just let me know when to refresh the page.
You can refresh every couple seconds. I'm going to just be deleting as we're going through these for efficiency's sake. Your Honor, there's only 2 more videos, I believe, that we have not discussed.
Okay.
Well, in this folder, and then there is we'll go through these first, but I'll play the 2 we haven't discussed. The first is the video that starts videos 1985 and ends in 71797. And I can publish it for the court if the court would like.
Okay. Well, no, I'm not on Zoom. So what did you say? It's 1797?
The last four, Your Honor, are 1797.
All right. I'll just play it up here.
Yes, Your Honor.
And is audio,
Yes, Your Honor.
okay. I'm gonna have to,
That's no cap. Pussy boy.
might need to start that one over. Sorry.
Block like no nigga get. 2 feet no nigga get. Bet y'all pussy nigga can come up here and hit block. Kill a ride on shit at your feet. That's no cap. Pussy boy. Yeah, that's what I'm saying.
All right. And the objection would be,
Cumulative, and also relevance, because I don't know who the other people are.
and the response would be,
So, Your Honor, this, he says, you can't come on this block, and mentions 250, which is in reference to 250 Cleveland. And then the state views as well when he says Little Rod will basically shoot at you. He'll shoot at your fitted in front of Mr. Ryan, who throws up the YSL sign. He adopts that. He doesn't push back. And so it's a public display of don't come over here. He will shoot you. And so the state, this is unique compared to other videos we've shown. And so the state does not believe this is cumulative and is relevant because it's a public display of do not come to this location or violence will come to you.
all right, overruled. And then what would our last one we're looking at be?
So, Your Honor, this last one is, it ends in 5, 6, 8,
Okay, I see it.
4, and this is, I believe, 12 hours after the murder.
No
And so-
objection to that one.
Okay. All right, so then is this the entirety of the evidence for this?
I believe they have 6 videos on the Word document.
And, Your Honor, I will have to operate those for the court because.
Okay, all right, that's fine. Let me just join the Zoom. Okay.
So, Your Honor, there's a Word document titled Ryan IG Live Stories that has 6 videos. So the state's going to be opening these. You have to open the Instagram return to play these. We're logging into the Zoom right now and pulling these up for the court. Your Honor, while we're pulling that up, well, I'm trying to think of something else we could, I don't want to waste the court or counsel's time. And so,
All right, I'm open to suggestions. So, I don't know, Ms. Hilton, is there something you could be pointing us to in the meantime?
Well, we just pulled.
Or, I don't know which, okay, it's not, have you screen shared yet? Because I don't see it.
I'm sorry, I'm sorry.
Well, is there something else we could be doing? Or are y'all both working on this, getting this pulled up?
We haven't pulled up on our. Mr. Atkins just told me video was posted.
Okay. Let's hope it goes faster than this during the jury portion.
yes, Your Honor.
If y'all want me to see, yeah.
That shit bothers me. Find blood and they can't see. Open your mouth, cause they won't speak. Heard that girl inside the bed where they on their knees. The devil on me, that's what
So, Your Honor, this was posted on February 21st of 2019. The murder was February 23rd. I don't know if definitively these are the firearms, but there was both assault rifle rounds and a 9mm. And so it's this, the state believes this is unique and relevant because one of the timing, and two, the person he is adding is Wooney Lee, who we've talked about earlier. And he shows both an assault rifle and a handgun in this video. So the state wanted to introduce this, given how close in time it is to the murder involving weapons of that type.
Okay, didn't we have something earlier that was being offered for the same reason?
Your Honor, that was an Instagram thread we did where I believe this was the one where someone was trying to buy
5
guns.
or 6.
Correct,
yeah.
Your Honor.
So pick between them.
We will use this video, Your Honor, and redact. I will find that PDF page number and not use that thread.
So which?
Do we need the audio?
What was the thread?
What thread was that, Mr. Atkins? What thread was that?
It was in the 5 October Mr. Sprinkles thread. It was when the person asked, he says, I will find it and let you know.
It was one of those it was the one that I said was okay about the back and forth with the firearms, but. Do we need the audio?
No, no.
Okay.
No.
All right.
The audio, Your Honor.
All right, next.
No sound, Rudy Gang. Around. Got the block down. Ladies ass thought like a stop sign. There's a whole lot of there's a whole lot of gunfire.
So, Your Honor, the state initially flagged this because we had referenced that Instagram post that says Rudy Gang, and his shoes and his comment is in similar reference to that of someone who had passed away. And so the state intended to introduce this just to show referencing that. Understand the court has previously admitted the photograph where he says that, so I understand if the court views this, would not want us to play this, but that's why the state intended to use this video.
Okay, so I
Cumulative.
would sustain a cumulative objection. Okay. Next.
Choose between the two.
I mean, honestly, it's clearer in the first one than it is here, I think. But yeah, whatever, y'all choose. Your case.
Which one is the state choosing?
We'll make that decision.
And let them know. Okay. Next.
There's no lie. Better work your move, cause I'm about to work my move. Slap with a dude. Now bitch that what he do. Yeah, I'm on the block. Twin Sarah.
Okay.
And Your Honor,
Go ahead.
the state was using this for the gang
Gang
hand signs. Yes, Your Honor.
Okay, so y'all have already got that.
Understood,
You
Your
can
Honor.
Pick between the two, but only one of them.
Yes, Your Honor.
Next. Mr. Sharp, y'all seem to be having more fun back there than we are.
We're just reviewing some surveillance, so we're ready when it's our turn.
Okay.
You always have fun.
20 cent rich ass block. You know, on Rudy Soul, I'm gonna pop. Cause I'm about to work my move. That's what I do. They look like Rudy.
And Your Honor, the state, given the court's prior ruling, and we will.
It's going to withdraw.
Yes, Your Honor. Yes, Your Honor. So I wanted to, those are the videos the state intends to introduce.
All right. All right, what's the next thing we move to?
Judge, we have many of the other witnesses. There are video interviews of some of the witnesses involved in the portion about Mr. Ryan. The state's contention, or I'm sorry, their plan is to use them only if needed as impeachment.
Okay.
We had asked the state, well, what redactions do you see that just blatantly this is not admissible.
Right.
They wanted us to, again, be the ones to go through and say which parts should be out.
Okay, y'all, I asked y'all weeks ago to get together on this, and that means at some point somebody needs to be the first one to say, well, how about this, or how about that?
And Your Honor, Ms. Abbasi and I.
You do it. You do it. Come on, y'all.
And Ms. Abbasi and I talked about this. She asked about the videos. I said, we don't believe that there's.
Where are we on it?
I told her that there's only one particular part in Mr. Mitchell, and it's when Mr. Mitchell's stepfather is talking to him about life. Okay. And I said, I don't think that that is proper. I said, if there's anything else, just let us know. If there's something specific that you are thinking of. And what her response to me was, okay, I will look at it and let you know. And she has not responded back to let us know.
Well, I could go through the ones that I have. The hard part on it is I have just timestamps. We don't have transcripts of this.
If she gives us the timestamps, we can look at the timestamps and either agree or disagree. We haven't received it.
This was supposed to be the day to do this.
Okay. Well, I can go through the ones that I have marked.
But we don't have it.
And y'all were supposed to have gotten together on it beforehand. And the y'all at this point is not just the state,
Yes.
It's also the defense. Okay, is there something else we can do?
I think that is everything for Mr.
Well,
Ryan.
how about one person over here on the state side get together with one person over here with Mr. Ryan right now and go outside and do that, and we'll pick up with something else.
I'll do because
All right, I don't care which one of you it is. Just one of you go work on this, and the other one stay here, and we'll do other things.
Here's my notes of what I think should be out.
Has this state, and I won't be surprised if the answer is no, but have y'all had an opportunity yet to formulate whatever response you're going to give to the 3 motions in limine that we just got this morning from Mr. Steele?
We have during the break. We was focused on Mr. Ryan trying
That's
to
fine.
stuff.
I mean, I know. I didn't get a chance to get around to that either. We've all been working hard on other things. So, all right. What's next then? Are you ready, Mr. Shard, on whatever it is that y'all were?
So, Ms. Hilton was kind enough to send a sheet with different body cam and videos that they sought to use.
Yes.
And I have reviewed them, and I'm ready to discuss them. On some of the videos, it obviously affects everyone, but these videos are involving Mr. Stillwell and Mr. Nichols and the arrest of Mr. Stillwell and Mr. Nichols. Mm-hmm. I know that Mr. Harvey had indicated that he had some objections.
I thought Mr. Harvey was supposed to be here today, so.
So and I'm not trying to draw the ire of the court or Mr. Harvey. I'm just saying that I'm prepared to discuss the matters, but I am not speaking on behalf of Mr. Harvey.
Okay, well, sorry. Who is representing Mr. Nichols' interests today?
I am, Your Honor, Lamar Gardner.
Gardner,
Gardner.
with a G?
Yes.
Okay.
Mr. Harvey is actually in federal court this morning at a funeral this afternoon.
What, federal court this morning and a funeral this afternoon, is that what you said?
Yes, Your Honor.
Well, he didn't ask to be excused, which is fine as long as there's somebody here, but are you ready to proceed on these body cams?
I'm not, Your Honor.
Well, I mean, y'all may just not get the chance to do it then. Because we had plenty of advance notice that what today was going to cover. All right, so let's go. Why is somebody from each table not leaving?
I was waiting, but I can go out first.
I don't care which of you goes, but. All right, what link or whatever should I be looking at for this tranche?
I am going, I think I go off the discovery as a search, so I think Mr. Atkins could better answer what Dropbox this stuff is in. But, just to take a couple things off the table.
Yeah.
The state has indicated that they plan to use surveillance video from the FedEx. Well, okay, I'll start with the BP. From the BP, which shows Mr. Drinks and other individuals shortly before the shooting on Windsor Street.
Okay.
It's surveillance video. There's nothing particularly, there's nothing misleading about it, so I don't have any objection to that. It just kind of is what it is. It shows the surveillance of that store. There's also surveillance from the liquor store, which is an adjoining building to the BP. Don't have any issue with that.
Okay.
There's surveillance from the FedEx building on Windsor Street. Don't have any issue with that.
Are these all short?
They're all short, and I don't have any objection to them, and there's no audio on any of them either. So once we take those off the table, we have a helicopter, a video from the helicopter, APD Phoenix video. Now the video, Ms. Hilton identified as helicopter camera.ts. When I found it in my discovery, it didn't quite say that, but I'm fairly certain we're talking about the same video. It's what we've deemed the slow speed chase of the white Audi. Is that correct? That's the helicopter video we're talking about?
Yes, Your Honor. And to answer the court's original question, if we go to the witness 53 to 100 Dropbox, these videos are contained within certain witnesses to make easy so we all know what we're referencing. And then I thought I had copied the court, but I will forward to Ms.
And you probably did. I just.
And I'm looking, I may not have.
So many emails.
I will forward to Ms. Percival now. I had sent defense counsel a chart essentially with relevant timestamps and the videos, and so I'll forward that so we can kind of go along so you can see this. I'll forward that now.
All right, so let me. Got it.
And I don't think I sent it to the court because it was 2 o'clock in the morning.
Okay, so I've got 51 through whatever it is, 103 up. So you'll just have to tell me which folder within each of them.
So this specific video that Mr. Shard is speaking of should be in Sergeant Newman's folder.
Do you know the number, the folder number? I have them in here by,
He will be towards the end, and Sergeant Newman is folder 83.
Okay. Oh, apparently it has 2 download, which might take forever, so.
I can share the video.
Oh, no, here it is.
Ms. Hilton,
Okay, and is this, so there are 5 different clips?
So it'll be the helicopter_camera.ts.
Dot.
It's the last.
None of them are labeled that. It's just helicopter camera.
And I'm sorry, I don't know why it says, if you go, are you in the Sergeant Newman folder?
Uh-huh.
Does it open up and say Phoenix Helicopter Officer Matt Peterson?
Yes.
Once you
and
open
then
that folder?
Within there, there's clip 41, 516171, and then one that's not labeled.
Well, on mine it says helicopter_camera.ts, so it should be.
Okay, well, there's no .ts, but, file type TS. Okay, so that's the one I need to be looking at.
Yes, ma'am.
I'm clicking and nothing is happening. There it goes. Okay.
Mr. Atkins originally sent this Dropbox link on August 30th, and then I resent it on September 12th.
Well, so far all it's doing is making me dizzy.
Oh, you were able to open it?
I'm watching it. I mean, it's helicopter view. I feel like I'm in a video game right now. Does it get to something relevant at some point?
It does. It begins the.
When you play it at trial, assuming that it is ruled in, can we skip the part where they're just flying above the city?
Well,
I mean, they might be looking for something, but they certainly haven't found anything yet.
They're just trying to orient themselves to the location. So when you're listening, they're on the traffic.
Oh, am I supposed to be hearing something?
Yes. There should be some audio.
Well.
Excuse me, Your Honor, may I step out for just a minute? Mr. Atkins as well.
Okay.
You're okay with that, right?
Am I supposed to be hearing something?
You should be. And I can publish it so you can hear, or.
Why don't you? Because I'm not hearing anything.
And I don't know if I don't know if we need to watch the entire video, so I don't know what Mr. Shar's objection is, because we might be able to get to that point.
Okay, so with that video.
Hang on, is this a 12-minute video?
It is, but it captures the entirety.
Or more than that? 13 minutes and 40 seconds? Okay, and what's the objection?
my objection is, I'm looking for the timestamp. I have it on a piece of paper here, but I think it's 10:05.
Okay.
The person in the helicopter says they or Shannon is armed, consider them armed and dangerous or armed and dangerous, and we don't think that is appropriate. Also, at the very end of the video, I think the state is of the belief that, I'll just say one of the two individuals threw a bag into a bush.
Okay.
And there's commentary from the helicopter pilot about a bag in the bush. Now, if I understand if the helicopter pilot saw it and he testifies that I saw someone wearing whatever throw a bag in the bush, then that's fine. But I don't think we need the commentary on the out-of-court commentary on top of the video. And that's at the very end.
We had a.
So what part of this do you want to show?
This is an entire chase. So it starts.
So who's chasing who?
So the police. So this video. So to orient the court is on March 17th, 2022. This is 3 days after the Drinks homicide.
Okay. 3 days after the Drinks homicide. Okay. 3 days after the Drinks homicide. Okay. 3 days after the Drinks homicide. Okay. 3 days after the Drinks homicide. Okay. 3 days after the Drinks homicide. Okay. 3 days after the Drinks homicide. Okay. 3 days after the Drinks homicide. Okay. 3 days after the Drinks homicide. Okay. 3 days after the Drinks homicide. Okay. 3 days after the Drinks homicide. Okay. 3 days after the Drinks homicide. Okay. 3 days after the Drinks homicide. Okay. 3 days after the Drinks homicide. Okay. 3 days after the Drinks homicide. Okay. 3 days after the Drinks homicide. Okay. 3 days after the Drinks homicide. Okay. 3 days after the Drinks homicide. Okay. 3 days after the Drinks homicide. Okay. 3 days after the Drinks homicide. Okay. 3 days after the Drinks homicide.
one of the gang investigators is at the Chick-fil-A on Cleveland Avenue. This car is a suspect vehicle at this point.
Okay.
And
Which is the white Audi?
the white Audi is a suspect vehicle. And while at the Chick-fil-A, the investigator's getting his lunch, maybe Mr. Stillwell, they're getting their food, and that begins a low-speed, high-speed chase. When the helicopters start going, Mr. Stillwell gets out of the parking lot. He does not get his food, and and they go on a chase. He goes the wrong way up streets, and he eventually gets to a home where he runs into a yard. He throws his phone away. We're able to subsequently apprehend that phone. They throw this bag of drugs away that's seen from the helicopter. They throw a book bag away that's seen from the helicopter. That book bag is subsequently recovered. It has drugs inside of the book bag. And so this is evidence of that interaction.
Okay, so the Audi is at the Chick-fil-A,
Yes.
and then a law enforcement officer is at the Chick-fil-A?
An undercover law enforcement officer is
Okay, and
behind-
then does that car start following the Audi or just the helicopter?
the helicopter and other cars. We have a trooper that follows.
When does it start? And when do we start seeing
the chase begins?
the Audi? This helicopter has been flying for 2 minutes and 16 seconds now.
Yes, Sharon, because
All right, Phoenix, we got our mapping system up. We can,
if you listen to the radio, what the officer who sees the car, he's giving Phoenix information. Here, he's giving
Phoenix being the helicopter
helicopter
from the outset.
From the outset. So what happens is the reason why the helicopter is orienting himself, the helicopter was at the airport, which is where it's at.
Okay.
And they are.
So can we, the part before it gets to the Chick-fil-A, do we need that?
We can start it at the Chick-fil-A because that is the relevant portion and play it into.
And that's at minute what? 2-ish?
It's about probably where I am at 1 minute and 15 seconds.
Well, actually, yeah, about a minute. It looks like maybe that's
Yes, because what it's showing is that they're focusing on finding the target vehicle and getting ready to be able to assist the officers on the ground with where the car is going.
Okay, and then how long does this, it's not, I mean, y'all are saying a slow speed chase. It's cars following the Audi. And how long does that go on?
The 13 minutes, that is the entire.
Do we need 13 minutes of that? Or can it just
Yes, 'cause you
be
see
at
different-
minute 1, they start following, and then here's when something actually happens?
Your Honor, let me reevaluate that. I think that the entirety is
'Cause, I mean,
important.
honestly.
Of what happens in this entire interaction, we will look at it and get back to court, but we believe that the entire thing is relevant. At 10:05.
Well, they might be relevant, but it might also be a waste of time
You're right, and we
to
will
watch cars kind of just following each other down roads
Mr. Stillwell goes in the opposite side of traffic. There's a number of different things that
well,
occur.
then pick out those parts and show those and condense it. Okay?
Yes.
Okay, so get back to us with a much condensed version of this.
So, in Your Honor, I agree with the court that a lot of this seems to be unnecessary to the extent that you're saying.
Do you want all 13 minutes in?
I don't, but the reason I'm not jumping up and down about it is
Well,
there's nothing egregious that my
that's
client
fine, but
does.
we've got to find some places to cut some time. And if there's nothing being shown other than the cars driving down the highway, I get if they're taking evasive action, fine, show that. But the stuff that's just, we're driving, we can just skip that and get to the points that are more relevant.
Okay.
And so, Your Honor, to the extent that whatever the video that's played, I do want to discuss the audio briefly. I know,
All right.
I feel like
so I agree that he's considered armed and dangerous, needs to be redacted.
and
What else?
That's from 10:05 to 10:10.
Okay.
And then from 12:35 to 12:40, there's a commentary about the throwing of the bag. Again, I
Is-
get it. If
Is the helicopter pilot going to testify?
Yes.
Okay.
And so, and I believe I thought we litigated that portion of it previously, but maybe it was just the drugs in the bag.
All right, so you'll redact that and he'll just testify to it, or it'll be on here and he won't testify to it?
It'll be
One
on
or
here,
the
he
other.
won't testify to it.
Now, I will say,
Okay.
because I'm trying to protect my colleagues' interests as well, Mr. Harvey in our discussions, his stance is that none of the audio should come in because it just doesn't serve any purpose.
Okay, and what would the purpose of the audio be?
Your Honor, so in the audio, the Phoenix sergeant or the sergeant piloting the plane is telling the individuals where to go, how to find where essentially the cars are because they're behind. So
Right.
that is the
Okay.
purpose of the audio, Your Honor.
But, I mean, we can see from the video that they are able to follow, so, I mean, you can ask him, and were you?
I wasn't planning on having him narrate through while he was on the stand, so I was just going to have him play the video, and as opposed to having him narrate.
Okay, why does it matter if the helicopter sergeant was the one who was able to direct, oh, he's turning left or whatever? Is it just things like that?
It is.
Okay, that's unnecessary. And he could just say in one sentence, I had a great vantage point, an eagle eye view, and I was able to direct them. Sure. If you want him to say something like that.
Okay.
All right. What else?
So there is a video of I believe it's dash cam of Trooper Mark Campbell. I cannot get that. Mark Campbell, Trooper Campbell, my understanding is the person who located a firearm that the state is attributing to my client and Mr. Nichols. And I've seen this video, but I can't get it to play on my computer.
Okay.
I don't think it's that long. I was wondering if we could just play that in court and just all
Okay.
be on the same page.
I couldn't. I told Mr. Sharp last night I was having difficulty getting it played as well, so I may need to go back to the
Where
back
we
to the
pulled it
trooper
from
where we got
originally?
it to figure out why we can't play it anymore because I was having some difficulty as well.
All right.
But
so
because
y'all
we-
tag that as something we need to circle back to, please. What would we be labeling that? This is who?
That is Trooper Campbell's.
Okay. Campbell.
Yes, and it's in
All
his
right.
folder.
Do you want me to see if do you know what number Mr. or Trooper Campbell is?
Yes, he is 82.
Okay. And is it the one that's, no, there's one that's East Point Photos. It's the other thing that's not that?
It should be the different, I'm sorry.
Pursuit? Is it Pursuit?
No. That not that 82. There's another 82 that says Corp Mark Campbell.
More than 182. Yeah, Corporal Mark Campbell.
And then the next one says GSP Trooper M Campbell.
Okay, GSP Trooper M Campbell, and then
Pursuit.
within there is Pursuit, and then within there is the one that's video player?
So the video player in the other folder, it appears that it goes to
Okay.
an internet-based system. So we need to just figure out how to get it again.
We'll come back to that one. So what, no, what's,
The last one in this area, and this is my fault because I did not remember that Mr. Atkins sent this email. I couldn't find it in the discovery. It's Detective Grimsley. It's 5 minutes long. I can either, now that I see it in this Dropbox, I can either step outside and just spend 5 minutes to review it, or if we wanted to just watch it in court, either way, and then I can just.
Where would I find it?
It's in that same Dropbox. It's Detective Grimsley.
Okay.
And it's a longer video, but the state is only seeking to admit, I think, the first 5 minutes. Is that correct?
Yes.
All right, there's a whole lot in the Grimsley file, so,
I can play the video, Your Honor.
well, or just tell me.
So it's the VidCam video, Your Honor, and what those 5 minutes are. This is a Vid camera that
All right,
is.
maybe just play it, because I'm not seeing something that's obviously.
It's just a lot of
labeled.
numbers. It's 7512. So in his folder, it should be a folder that says photos.
Yeah.
And then the second video, which is the MP4.
I don't.
You don't see
I
it?
don't see it, so can you just play it for all of us?
Yes.
And what's this going to be showing?
And I guess I think it's probably simpler for me to just talk because there's no sound.
Okay.
But in this portion of the video, Your Honor, when you're looking from here, you cannot see it. But if you look to the far left of the screen, that's the BP gas station.
Yeah.
Where Mr. Drinks was prior to his homicide.
Okay.
And Detective Grimsley has the ability, even from this distance, I know it seems interesting, but he was able to see the specific times in which Mr. Drinks' vehicle, the Audi, and the other vehicle leave the gas station initially from the distance. This is something that may or may not come in, but that's what the purpose of those 5 minutes are.
Okay.
And then from here, what the testimony will be is Detective Hogan saw this video first. And because of this video, that is why he went down to the BP to actually get the actual surveillance video from the BP gas station and the other 3 locations, Your Honor. So
the purpose of this video is to say that the detective saw this and it led him to want to go get more video?
And that's all. And again, these are just, we put items in here where, that's what this video is.
I'm trying to understand. So Detective Grimsley, off of that video, and Ms. Hilton, I'm not coming at you. I'm trying to understand. Detective Grimsley on this video is able to look in the upper corner and see the cars leaving?
I mean, you can see cars coming and going. I don't doubt that. But I mean, if the only purpose of it is.
But he's able to, and you can call him and question because we talked about it as to how and why he's able to do that. But he is able to, yes.
Okay. Well, I mean, just ask him those 2 questions, and if you even need to. Why do we need to get to what it is that he ultimately saw on a better?
We are ultimately talking about the investigation because one of the defenses that some of the investigation has not been the best. So this is just all the steps that APD took in the initial part of this homicide in order to solve it. And so this was one of the steps, the investigative steps that they took in order to solve this homicide.
I don't think that we need to be worried about that. So let's.
The state has the burden, so we have to worry about those things,
Okay,
Your Honor.
well, then I am going to rule that it is a waste of time under 403. And then if the defense wants to question, well, how did you know to go to the BP video and get that, then you can play it. But otherwise, no. Next.
That, unless I'm wrong, Ms. Hilton, I believe that concludes all of the body cam video regarding the drinks case. Is that?
Okay.
Yes.
All right, super. All right, Ms. Hilton, what else do we need to still consider the admissibility of? Have we covered everything?
I think so. The only other things that I can think of, and I'll need to get Mr. Atkins, is the follow-up questions we had from the wiretap. I think we had those 3 or 4 audios we had to revisit today.
Oh, right.
I believe, and if I didn't, I will. I did edit the demonstrative that we talked about regarding the phone records, and I sent that. I believe I sent it, and I'll just double check that I actually sent it, but if not, I will, regarding the text messages that we discussed on Wednesday, I think. With the Verizon text messages and the color of the Verizon text messages, what the demonstrative would look like. I believe I sent. I'm going to double check.
Okay.
If not, I will get that to defense counsel.
Okay.
I believe that may be it.
Your Honor.
Yes.
There's also some of the arrest at Mr. Williams' home. On May 9, 2022, there are 3 drone that the video, I don't believe audio, that the prosecution wishes to introduce.
All right, and is there objection to them?
Yes.
Was this the one that y'all had sent the email at the end of the day about?
Yes.
All right, I thought y'all were saying like they're not particularly prejudicial, but they're also not particularly probative. And I actually took from that y'all didn't care, but are you making an objection?
Yes.
Okay.
Unless we have the wrong times or something, it would be a 403. It's just there's nothing.
I'm sorry, I didn't mean to cut you off.
Sorry. There's nothing there. It's a drone sitting and looking at a
Very
couch.
little probativity. Okay.
And there are certain portions of that drone video, so we'll look at it, we'll consolidate it, and we'll send it back over to defense. What we plan on using, and see if there's still an objection.
Okay. Does that work? Did they try to shorten it to whatever might be relevant?
It works just fine, but why make us watch 45 minutes of video where
I don't
one
know.
one of the videos was 15 minutes of a drone sitting on the floor, but we had to watch the whole thing to make sure there wasn't anything else there. I would just ask for more they've been great, but more consideration in the future on that.
Can y'all try to think through, it should come as no surprise that both the defense and the court would prefer, and I'm not doing it because the defense prefers it, the court would prefer it for these poor jurors who've been here for 9 months already, that things be as streamlined and concise as possible.
That is the plan, Your Honor.
Okay, and I know that y'all's universe of evidence is almost boundless, but try to do the best you can before we're in court trying to evaluate admissibility, have gotten it already down to what you think is actually relevant.
Yes, Your Honor.
Okay, all right, they'll get back to you on that, and then y'all can let me know if there continues to be an objection, in which case I will look at the smaller window of video and rule on it.
Thank you, Your Honor.
Okay. All right, so, I don't know if that's, Mr. Shart, I had a note that said Stillwell cell phone search. Is that something we have yet to deal with?
You're right, we have not dealt with it.
Yeah, sadly, the search and seizure aspect of it has been litigated. And
Okay.
I did not win those arguments.
Okay.
But the contents that the state is seeking to admit, I'm still waiting on the specific pictures, texts, whatever they plan on using for my client's phone.
Y'all don't have that yet.
I have the
You
contents of
have
the phone.
the entirety of it. You don't have what they've narrowed it down to.
Correct.
Have y'all narrowed it down?
We have a few other colleagues are working on that, so we'll be able to get that to Mr. Sharp by next week, Your Honor.
Okay, so I don't yet know when our next non-jury days are going to be, and I mean, hopefully we have enough to carry us through five, but if we don't, it's going to greatly perturb the court that has not been provided in a more narrow form yet.
I will reach out to the individuals who are working on that right now, Your Honor.
Okay, do that. All right, so there were a couple of things that we had looked at yesterday, but then we're going to come back to. So maybe we can come back to them. And I'll give you a minute to send the message.
Thank you,
Since
Your
I know you're the only person for the state in here right now.
Okay. I'm ready.
Okay.
One of those, I'm ready, Your Honor.
Good, okay. So y'all were going to look and see whether, or the gun that, let me start over. On witness Mary Furlow Lewis, or around there, Mr. Zachary's gun matched these cases, and I had wanted casings, and I wanted to know if there was evidence that he had possession of that gun at the time that this September 30th shooting occurred.
Yes, Your Honor. Ms. Love was looking into it. I'm confirming now and see if she was able to get the information. So that's what I am waiting for now for a response.
Okay. I had, if y'all are going to call Tariq's sister, you need to get that information to the defense.
We are going to be, just want to confirm that's one. We will not be presenting that incident.
No? Okay.
No.
Well, I mean, it was around witness number 44.
43 and 44.
43, 44. So does that mean, won't you be presenting?
We're not presenting that incident at all.
Okay.
And the incident above that, 41 and 42, we won't be presenting at all.
All right. We've just saved ourselves 2 hours. Okay. On number 63, Officer Greer, there was a question about relevance of Huey having given 2 fake names before his real name and date of birth. And then I don't know why we were coming back to that, but.
Yes, Judge.
Why were we coming back to
Well, yeah, that was why we were coming back to that.
Okay.
So, Judge, Mr. Huey was arrested on the date that's indicated on this document.
Yeah.
There's an allegation that he gave these two fake names and then eventually admitted his real name. So he's not charged with any of these allegations of giving a false name or anything of that nature as a count. It's not alleged as an overt act. We haven't heard any argument that it's somehow intrinsic. So I don't think that it should come in on a basis of relevance. I think that there is a 403 argument to be made with respect to prejudice, character, and there should be I'm arguing character as well. So relevance, 403, and character would be my bases for asking this court to exclude any mention of Mr. Huey having provided a fake name and then eventually gave his real name and date of birth.
All right, what's the state's response?
Yes, Your Honor, we believe that is very relevant. This is approximately 1 month after the armed robbery that Mr. Huey is alleged to have committed in April of 2019. And given that when he is stopped and asked initially what his name is, he tries to hide that information. The state decided not to charge him, but it is important that he decided to first not reveal who he was because there was a warrant out for his arrest, and hence he was arrested after he gave his name.
Okay.
So, Your Honor, my response would be that the state isn't able to establish that on this particular date that Mr. Huey knew that he had an armed robbery arrest warrant pending. So that would be totally speculative that, he gave a false name because he had an armed robbery warrant. Unfortunately, sometimes people give false names for various reasons. Sometimes they just give a false name.
Yeah, but one of them could be consciousness of guilt. So I am going to admit that over objection. All right, so that takes care of that one. And let's see. Number 68, Sergeant Henderson.
Yes, Your Honor, we were discussing what exactly he would testify to as it related to the until the October 2020 armed robbery. As we stated yesterday, Sergeant Henderson not only investigated the October armed robbery, but he also investigated the April 2019 armed robbery involving Mr. Huey. As it relates to the October armed robbery, he will talk about Mr. Huey had a phone that day as well. He received consent to search that phone. The day that Sergeant Henderson interviewed Mr. Huey, he obtained his phone, was able to go inside of his phone. That phone we will be seeking to admit that cell phone into evidence and contents of that cell phone into evidence. And so those are some of the items that he will testify to. I think the question is, what else would he testify to besides speaking with Mr. Holloman? So those are just some of the other items that he will be testifying to as it relates to the incident that occurred in October of 2020.
So, Your Honor, in response, Sergeant Henderson interviewed Mr. Holloman, and the court has already excluded on the basis of confrontation clause and Mr. Holloman not being here with us. So an interview, photographic lineup process, that's all already been excluded and kept out. The other issue is that in the document here before us, the state is indicating that he's going to testify to, quote, similarities in an April 2019 robbery, and it says with Fleetwood. There's been no evidence that I'm aware of where Mr. Fleetwood was charged with an April 2019 armed robbery. So similarities and things of that nature, I think that that's going to create a 404, maybe a 404B argument that we haven't received notice on. Not sure how this Fleetwood person is going to be injected into this discussion with Sergeant Henderson in terms of testimony, and they indicated they were 4 days apart. So I'm going to object on that on the grounds of relevance. There's been no proffer, no showing that a 4-day alleged armed robbery with Fleetwood is somehow similar. So I'm not clear what their basis is going to be for attempting to introduce some extraneous alleged armed robbery with a Mr. Fleetwood.
And when we say robbery with Mr. Fleetwood, do we mean Mr. Fleetwood participated as a co-perpetrator, or Mr. Fleetwood was the victim?
So, Your Honor, Acts 85 and 86 and 87 are an April 22nd, 2019 armed robbery in which Javon Fleetwood is a defendant who is a YSL co-conspirator. In that April 22nd, 2019 armed robbery, Mr. Fleetwood is alleged to have robbed an individual in the Jonesboro South area. The way that Mr. Fleetwood gets to that armed robbery location is in a black Mustang. That black Mustang is what's going to be the relevant piece of information. Mr. Fleetwood gets out of that black Mustang, out of the passenger side of that vehicle, goes inside of a building, robs an individual, and steals his car. 4 days later, this armed robbery with Mr. Huey takes place, and the suspect vehicle in that armed robbery is a black Mustang. We have pictures of Mr. Fleetwood and Mr. Huey together in Instagram. We have pictures of that black Mustang that we believe is the same Mustang used in both incidents. So there's some similarities between the April 22nd, 2019 armed robbery, which is 3 of our overt acts, or
The April which?
they are 85, 86, and 87.
The April 22nd with that Fleetwood is alleged to have perpetrated
Yes, Your Honor.
are overt acts.
85, 86, and 87.
Okay.
And these overt acts happened 4 days after that armed robbery.
Okay, can we ask IT to figure out why we are having sound issues again, or do you already know? We just have cheap microphones. Okay. Okay, so if these are overt acts, then y'all ought to, that are listed in the indictment, y'all ought to know about them.
So, Your Honor, with respect to how they are attempting to somehow link, I guess, a Fleetwood case with Mr. Huey in terms of similarities, what we haven't heard is that this particular Mustang, we don't have a tag number for this Mustang. We don't have an identity of anyone who is allegedly driving this Mustang on this date that this Fleetwood case allegedly took place on. We don't even have evidence of who is supposedly driving a Mustang with respect to this incident concerning Mr. Huey. We don't have a year, make, and a model. We don't have. What we have here is that, that we have a black Mustang, a Ford Mustang. I guess that's their connection of black Ford Mustang. And somehow that's supposed to link to two armed robberies on different dates.
Okay, so in what? This officer will be saying what?
Investigative.
I was already investigating this other one, and I noticed that, are they both in the same area of town?
No.
No, so ironically.
So what are what would he be saying was similar?
Because when I say similarities, I mean the fact that Javon Fleetwood and Marquavius Huey are friends based upon Instagram, based upon that. So in the armed robbery on April 22nd, 2019, Mr. Fleetwood arrives
And a black Mustang, and gets out of the passenger side of it to go perpetrate the armed robbery.
And then 4 days later, in the Buckhead community, a very similar black Mustang is involved in that armed robbery of Mr. Maynard.
And that Mr. Huey is...
And Mr. Huey is driving that
alleged to have been the driver?
No, he's alleged to have been the perpetrator of that armed robbery.
And did he get out of the passenger side?
Or does anybody know?
It's not alleged.
It's not, we cannot tell from the surveillance video. What we know is the victim will say, I saw and heard a black Mustang, we believe an individual in a yellow jacket, we believe to be Mr. Huey, is in that area. Then we have Instagram posts of Mr. Huey in a black Mustang that he is saying that he has possession of, that is his Mustang. He has about 2 or 3 pictures of himself in this black Mustang, all in and around the time of these 2 incidents. So circumstantially, Your Honor, Mr. Huey was never charged in the April 22nd, 2019 armed robbery, but the fact that this black Mustang is involved in 2 armed robberies very close in time with 2 individuals who associate with each other is what those similarities are.
And Judge,
Okay, but in 85, 86, and 87, the state is only asserting that Fleetwood did these things, right?
Correct, yes, Your Honor.
right. And then, Judge, if I could just respond to the court's initial question regarding where is it alleged that these perpetrators in the Buckhead armed robbery, according to the witnesses on scene, the alleged victims, they are claiming that 2 individuals, that there was a driver of this Mustang, and they indicated that 2 individuals got out of the back seat of this Mustang and began to. So to answer the court's question, there's no evidence or indication that Mr. Huey, again, was at this Fleetwood alleged armed robbery. There's no indication that Mr. Huey was driving a Ford Mustang at this Buckhead alleged armed robbery. I think all we have here, Your Honor, is a black Ford Mustang that is alleged to have been involved in 2 armed robberies in 2 different parts of town. There's no evidence or indication that Mr. Huey was involved or part of this.
Okay, but there is Instagram from Mr. Huey's Instagram that shows him to be claiming ownership of a black Mustang?
Yes, Your Honor.
Well, there's Instagram photograph that shows Mr. Huey in a photograph with not only a black Ford Mustang, with an Infiniti, other vehicles. There is an Instagram photograph with Mr. Huey being in the same photograph with a Mustang. Yes, but there is no evidence that Mr. Huey owned a black Ford Mustang.
He was around, had access to.
But in terms of the connection,
so
I think it's
this
tenuous.
investigator is going to say what? Was he already investigating the April 22nd one?
Yes, he was assigned the April 22nd armed robbery, 2019. He was assigned the April 26th, 2019 armed robbery. And interestingly enough, he ended up investigating the October 1st, 2020 armed robbery.
Okay.
So he investigated all 3 armed
And
robberies.
so he's just going to say, so he's going to be testifying about both of those armed robberies at the same time?
Yes.
Okay. When he's on the stand.
Yes.
And he's going to say a black Mustang was used in this one.
Yes.
And then he's going to say a black Mustang was used in this one.
Yes. Yes.
That's it.
Okay. Well, I mean,
I don't
he can
see how
say
that's-
both of those things.
I don't see how that's, again, Your Honor, I just would argue for our purposes that the connection is not enough, and under
What do you mean is not enough? I mean, I don't think he's not going to say, so I think Huey was also involved in the Fleetwood armed robbery, is he? No. Okay, well then,
Right. He's not going to say that. He
he's
can't say
not
that.
going to say that.
Can't say it.
Correct.
Okay.
So does that wrap up the issues for this?
For us,
Okay.
yes.
All right, so is there anything else about Henderson's potential testimony that we need to sort out now? Or that we can sort out now?
I think we're okay, Judge.
Okay, all right, so I will take that tab off as well. All right, and then next,
And Your Honor, I have a response to Ms. Mary Lewis.
okay,
Your Honor, the state will not introduce that act unless and until we determine whether or not Mr. Zachary was in possession of that gun
Okay,
prior to this date of
all right,
September.
thank you.
Can you repeat that number again?
It was witness number 7, basically, or 6 and 7, I guess, unless they can confirm that Mr. Zachary was in possession of the gun
Understood.
prior to that September 30th, then they won't do that act. All right. The next thing we were going to circle back on was witness 71, which is Viverito. There had been some question about exactly the scope of the court's exclusion of a chase or parts of a chase or something about a chase. And I thought y'all were going to let me know either what trial day that occurred or what actual calendar date that occurred so I could go back and look. Did anybody get a chance to do that?
Well, we were searching, Your Honor, and there are a lot of days here, and we have not been able to track exactly what day that took place.
Your Honor, and we recall that this court excluded, and we cut those witnesses. The court excluded Mr. Huey for the October 20th armed robbery was arrested a year later, and the court said that that was too remote in time for him to know that he was.
Yeah.
And so we cut those witnesses.
Okay.
I mean, Investigative Reso was not going to testify today.
Okay,
So
'cause
those witnesses are cut.
Okay, so then Viverito is not going to be dealing with social media video of Huey showing people in jail the car he purchased, which is the same used in the high-speed chase?
If the social media video comes in, we will not talk about the fact that that was involved in the chase.
Okay, so for what other purpose would the social media video come in?
I need to look at it again to see if he is associating with anyone else, but outside of that, it wouldn't.
Okay, so this probably would not come in.
Yes.
Thank you, Judge.
Okay. All right, so that was all we needed to circle back on those.
Your Honor,
Yes.
did talk to the state yesterday concerning witness number 66.
Okay.
And I think the state indicated that they were going to take my basis for indicating how this particular information would come in. It says it was a Joe call that we're talking about. If you look over in the right column, in the far right column,
Okay. Yes.
and if you look at what's indicated in the parentheses,
Uh-huh.
I had a conversation with the state concerning that fact and that they could not play that particular information through any other witness other than witness number 66. And they indicated they understand my basis for that evidentiary objection and that they would consider that. Did I get that right, prosecutor?
All
Yes,
right,
Your Honor,
and
we
so-
intend to introduce it through Ms. Stanley.
Okay, so we can cross out the parenthetical.
Yes.
Okay, thank you for
Thank
bringing
you.
that to my attention.
Thank you.
So on each of these crime scene techs that are the planters people, well, and frankly, all of the crime scene techs from here on out, this jury's already heard lots of crime scene techs. And y'all have assured me that these people are going to take a very short amount of time.
The planters people, yes.
Yeah, so I just want to make sure that you do not plan to have an entire, like, where have you worked throughout your entire life and what's your education and blah, 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 and what do crime scene techs do? And Because they already know that what crime scene techs do, and frankly, all we really need to know is on whatever date I worked for APD or whoever it is, and I was a crime scene tech, and then move straight on to the condensed version in testimony about whatever it's showing.
Yes, Your Honor, we
Okay.
did that in when we gave those times yesterday.
Super, thank you. All right, I'm going to look back through my notes to see what else we might have needed to still be circling back on. And y'all, unless y'all know of something already that we can do right now.
And I'm sorry, Your Honor, I didn't mean to cut you off. We got the my colleagues were able to get the GSP video. That
Okay.
We was working about to double check, but if we need to circle back to the.
That 5 minutes? Okay, why don't we go ahead and watch that?
Judge, why did you like to address the overt acts, the basis?
What now?
Why don't you like you want to know what can we address now? Why would you like to address the state's position that they can use overt acts which are not in the indictment solely to support the conviction? When did you like to review that?
So unfortunately, I have not been able to read yet y'all's briefing on that, so not yet.
Yes, Your Honor.
Okay, but thank you. And you know that on the intrinsics, because you were involved in that,
Yes, I
that
have.
those have all been ruled on. Okay.
Thank you.
Your Honor, just to orient, this is that same chase that's on the helicopter but on the ground.
Okay.
And we can watch both of them.
Where?
I don't know what the objection is, but
I think he couldn't see it, right? So he just wants to see it.
you want to see it now or just have to watch it?
Well, I mean, I hadn't seen it either, so you're just watching it now, right?
Yes.
Okay, so yeah, and it's, go ahead.
And we're playing, the state is seeking to play from beginning to when the gun is handed over, correct?
Correct, and based on the court's other ruling, some was made short, but we'll play to that portion
Okay.
now so the court can see it.
And do we need the sound? Yeah.
Where?
Y'all are gonna want this sound, right?
Where? Bill, what's my watch? Bayfield Road, doors open.
Was there a warrant out at the time?
Bayfield Road, Nancy Dawn.
So are these people trying to get to where the Audi is?
So the Audi is, so what happened is a number of details come in to help get the apprehend the individual.
Bill Van Hill.
Trying to get there.
Yeah, I mean, is there an outie in?
That's why the helicopter, because the helicopter's calling out over radio.
Right, so these are officers who are like, oh, I can help with this chase, let me get to this area?
Well, on the middle arc.
Yeah, so now
On the middle arc.
he's directing them to where they are now.
Right, okay, and so why would it be relevant?
We can get
We're just watching it all now, but this part is not anything you're gonna offer, right? Okay. Can you skip to the part that, okay. Those GSP cars go fast. This is not a chase, but it's definitely high speed.
There was a gun back there. There was a gun in the street. I'm gonna go back and get it. Boulder Way and Meadowlark. Meadowlark, the left Meadowlark. Meadowlark running off foot.
And do we know whether this is the same route that the Audi took?
Yes, because the Audi is, we know from the helicopter, it's the same with the Audi.
Y'all get that gun? Huh? Did y'all get the gun? Through the fence to the right of the house, reveal. It was in the street.
The house where Mr. Ever hit is on this street.
Hey, somebody get over to Ore Drive. Ore Drive, that's where it's at. Where it comes out to where they're
Is
running.
this officer going to testify?
Tony, you out there? Can you give you an update? Yeah, I'm out here. I'm trying to get to where they're running to.
Takes it and gives it to law enforcement. That gun is significant because
Do we see the gun on the camera ever? Okay, let's skip to that
I think
part.
numbers on Boulder Way was 24 maybe. Might be.
I do.
I don't know yet. Did they say they tossed the gun? But this is the gun. They're on around the curve.
All right.
I don't know what they want me to do with this.
Right there with it. People who said, I saw a gun get tossed, or what?
no, we believe, and we just don't have this because they switched radios, but the first officer is an East Point officer who eventually, a police officer was able to get directly behind the Audi. That was Captain Glover from the East Point Police Department. He does not recall now, so we can't bring in, we believe on radio someone said they tossed the gun.
Okay,
However,
but y'all don't have that evidence, and he can no longer recall.
remember that. So what happens is by the time he gets around Trooper Campbell, he sees the gun in the middle of the road. He picks it up. He gives it to APD. That gun is eventually ran. It comes back to the girlfriend of Mr. Stillwell, Miss Alexander. And then that gun, there's a knifing hit to shell casings that are found on March 16th, 2022 that we confirm. So that's...
Okay. All right. Mr. Sharp?
I missed that last part. The knife in hit is
Sure, so it appears on March, from the evidence we gathered from the shooting on March 16, 2022, where we believe individuals from the opposition gang shot at the house, there was returned fire. Some of the shell casings matched this gun found in the middle of the street.
All right. And all right, having now seen the video, is there objection?
My objection is with the audio, the commentary. I mean, because it seems to me, I'm trying to place this together. I can't remember his rank, but Glover, my recollection of his testimony, and this is when we had the prior judge, he testified in some sort of, I think it was a motion to suppress. My recollection is he specifically said he personally did not see anyone throw anything from the car.
Okay.
Because he was the closest person. There seems to be some rumor, like Ms. Hilton was saying, that something was seen thrown out the car, but there's no identifiable source to that rumor.
Okay.
So to the extent that the audio includes discussions about who saw them throw this out the car, I would object to those discussions.
Okay, so I do think that that last part where he walks up and is saying, hey, did anybody say that, needs to come out. But this officer says on the radio, I saw them toss a gun, or no, he didn't, I'm sorry. I see a gun on the street. I'm gonna go back and get it. Are you objecting to that audio?
I believe he's testifying, so he could testify to such.
Okay, and what would the state's response be?
He is testifying, so we can ask him, or we can just say, is everything captured on the body cam video? We'll say yes.
Okay, that would be fine, but can we don't need all of that lead in beforehand where they're getting to the relevant place. So if you want to just, pick it up right before he sees that, and then it's fine to go back to here and show him, get it, and have it in the bag. Okay, so a shortened version with that last part of the conversation redacted. Okay. So we have still not sorted out that one wiretap that was the 2119, and so we waited for Mr. Harvey to get here, but Mr. Harvey is not here, and we need to figure this out. So, and I mean, everybody briefed it, or Mr. Harvey briefed it, and I think the state briefed it.
Your Honor, and Ms. Love was handling that. I don't think we briefed it.
Well,
she was doing the research for it. This is the hearsay within hearsay one?
Well, maybe not briefed, but like sent case law or whatever. Y'all had plenty of time to send submissions, and some people did. I really can't remember who all did, but does anybody want to say anything else about this?
Your Honor, I do know that we were waiting on the state to file a response to our motion. I'm sorry.
I don't think so.
I believe our last discussion was we were waiting on Mr. Harvey's return.
Mr. Harvey's version of the conversation?
No, wait for him to return to argue. That was the
Yeah, well, he's not here. And he was supposed to be here. And there's an attorney here for Mr. Nichols who says he's not prepared to argue it, but I'm prepared to decide it. So if somebody wants to argue in Mr. Harvey's place, have at it.
Your Honor, it's my understanding that the legal issue, is that on the wiretap, it seems clear, at least to to me that it is capturing Mr. Garlington's wiretap, speaking with Mr. Stillwell, and they're talking about what other people say, and then the issue that we want your honorable court to wrestle with is there seems to be a break because some of the information comes from a man named Rel, who nobody is alleging is part of this conspiracy.
Right, and what Garlington is repeating, he only knows because of what because Rel told him, right?
That's my understanding. So dealing with that, the state's position is if it comes from, the way I understand their brief, and it's that short page, I forget what number, but I have it. But they cite a Second Circuit case, I believe, my memory, saying that if it comes from a co-conspirator, you don't have to apply, it's 801 D2E, then therefore you don't have to apply the hearsay, double hearsay, or triple hearsay exceptions. And I don't believe that that is.
I mean, I understood their argument to be like, you don't have to have, the person saying it doesn't have to have personal knowledge, but that's really not what would keep it out. It would be, it's still nested hearsay, and so there would still have to be a hearsay exception for the nested part of the hearsay to come in.
That's my understanding.
Yeah.
And that's under 24-8-805 in the Georgia Code. Yeah. And I would like to give you a couple cases if I could. And
well, if it's just for that proposition, I already think that proposition is the law. So you don't need to. You can cite them for the record if you want to.
Sure.
But I'm with you on this part.
Okay. And I believe that I sent this, but if I didn't, I apologize. But I have several cases. I have copies if you want them. But Lewis, Lewis versus Odom, Odum. Your Honor, it's 2022 U.S. District Court Lexus 19227. Westlaw, if anyone needs this, 2022 Westlaw or WL 304671. It was decided January 3rd, 2022 in the Southern District of Georgia, Augusta Division. And would you like a copy?
Yes, please.
Your Honor, would you like a copy?
Sure, if you've got one.
I do. May I approach?
Yes.
It says exactly what the court just announced, and it's allowing me just to make the record. And if you look at the copy of the case I've given the prosecution, this honorable court, the Honorable Ms. Persifield, it's on page 15 of 17 on the right-hand side. The first full paragraph, or maybe the second paragraph, it starts with moreover. The state habeas court ruled Mr. P.O.P.E.I.L. did not provide ineffective assistance on this point because such argument was meritless under Georgia law. In denying relief, the state habeas court ruled as follows. Under OCGA 24-8-801 D2E, a statement by a defendant's co-conspirator made during the course and in furtherance of conspiracy is not excluded by the hearsay rule when offered against the defendant. Furthermore, under 24-8-805, hearsay included within hearsay shall not be excluded under the hearsay rule if each part of the combined statements conforms with an exception to the hearsay rule. And that's what you were just saying. And then in that case, they found that every part of the statement did meet an exception to the hearsay rule. And I don't believe, it's my challenge to the state, that I don't believe that there is any exception I can think of to woman rel or Mr. rel, R-E-L, the way I read it. So that's my issue before the court, and I think it breaks the chain, therefore, because it is just hearsay without an exception. I have an 11th Circuit case as well. And that is United States versus Barsoum, B-A-R-S-O-U-M. Your Honor, it's 763 F3D or F3rd, 1321. It's 11th Circuit, 2014. May I approach?
Yes.
Can I give you a case? And Your Honor, on the copy I've given this honorable court, Ms. Persifield, prosecution, Honorable Carton Matthews, on page 14. It's in Division F, as in Fox 2. On 14, it's under analysis on the left-hand side bottom, and then on the right-hand side, the first full paragraph, the 11th Circuit wrote, "We affirm the district court's decision to admit this portion of Stevens' testimony because it did not relay any out-of-court statement." And then if you skip, Your Honor, 8 lines down to the right, the court wrote, "Stevens' testimony references the existence of conversations with Wabi, W-A-H-B-A or WABA, but does not convey an out-of-court assertion. Instead, Stevens testified only to his personal knowledge, namely, what led Stevens to believe WABA understood the prescriptions were fraudulent." And the next paragraph, "We also disagree with Barsoum's argument that the government had not sufficiently established a conspiracy involving WABA and Barsoum as co-conspirators," and they go through that. And then at the very bottom of that section on the right-hand side, same page 14, the last 2 lines, "Thus, even if Stevens' testimony conveyed out-of-court statement assertions by WABA, we would find no abuse of discretion because the evidence showed that there was a conspiracy involving WABA and Barsoum, and that WABA's statements to Stevens were made in the furtherance to further that conspiracy. We therefore need not address whether the omission of Stevens' testimony was harmless." My point is, if it was simply the way the state said it, they would never go through an analysis that the person was not relaying an out-of-court statement. It was based on his personal observations. So those are the cases that I found that I thought would assist the court. I know you already said that that is your understanding of the law as well. So I believe that there's a chain broken, and therefore I would ask the court to exclude that conversation of the wiretap, or that portion of that conversation. It's a long conversation, but that portion.
And what's the state's response?
Thank you, Your Honor. The state's response, and we'll speak specifically to what we believe Mr. Nichols may or may not have said to Rel, because that is the chain that I believe defense is saying is not broken, or is unbroken, because we have Demekion to Mr. Stillwell saying that Quantavious, so those are 2 co-conspirators, so Quantavious, co-conspirator, told Demekion.
Okay, hang on. Nichols is back up and just say that again.
Sorry.
Sorry.
So the chain as we understand it is Demekion speaking to Mr. Stillwell, and Mr. Demekion is now conveying what Quantavious told him. Right.
Quantavious.
Greer, who is a co-conspirator. That statement that Quantavious Greer says is, "I spoke to Rel."
Right.
And Rel told me that, or Quay needs to chill because Quay is saying that he needs to pay for our lawyer because we did this stuff for him. That's what Rel is telling Quantavious. Excuse me. That is what Rel is telling Mr. Greer, and Mr. Greer is now relaying that to Mr. Garlington, who is now telling Mr. Stillwell.
So which Quay is this?
The Quay who made the statement to Rel allegedly is Quarmavius Nichols.
Okay, that's what I thought. Whose name you didn't even mention in here.
Because I'm just trying to get the link together first. So what we have is Quarmavius Nichols speaks to Rel. That's what we believe. If we believe what Quantavious Greer is saying, Quarmavius Nichols talks to Rel.
And says, tell Betty, dang, get a lawyer.
Because we did this for him.
Yeah.
And that is now being communicated from Rel to Quantavious Greer to Mr. Demikian to Mr. Stillwell. Between Greer and Demikian, that's co-conspirator hearsay. Between Demikian and Stillwell, co-conspirator hearsay. The issue is what Rel said to, what Quarmavius said to Rel. Or excuse me, what Rel said to Quantavious.
Right, because
Yes.
what Nichols allegedly said, if he said it, would be against penal interest, is what y'all argued before. But it's the Rel portion of this that, where's that exception?
So, Your Honor, I want to turn the court to United States v. Ragosta, which is a January 25th, 2013 case. 522, Fed Appendix 663.
Is this in y'all's brief from, have you given me this case site before?
I don't believe so. And we have a copy for the court, Your Honor.
Okay. Just love having to do all this on the fly. Okay, what part am I supposed to be looking at?
And Your Honor, on my page 7, do you have a 9-page document, Your Honor?
Yes.
Okay, on page 7 of 9.
Yep.
And if you go to the second paragraph, and it talks about Mr. Ragosta now argues the topic of the conversation between co-conspirators. And I want to specifically go to the fact that what Quarmavious may or may not have said to Rel is not hearsay, because it is a order versus, so listen, when you look at this case, Your Honor, the statement that Mr. Ragosta tried to keep out was a statement in which it was a specific order, and I'm just trying to find the language of what the command was that he was trying to keep out.
Nicola's demand that his sons be paid more money. The conversation contained inadmissible hearsay within hearsay, at least insofar as it relayed that demand, because Nicola was not himself a co-conspirator. Is that the part?
Yes, Your Honor.
Okay.
And so in this case, what we believe is said is a demand that he being Mr. Williams, should pay for our lawyer because we did this stuff for him. It's a demand. It is not, based upon this case, it's not hearsay, because that's what this case says. It's a demand. He's telling.
But that's Nichols who's allegedly saying that.
Who's a co-conspirator.
Right. And if it were Nichols to another co-conspirator to another co-conspirator, there wouldn't be an issue. It's that he said it allegedly to somebody named Rel, who then repeated it to co-conspirators.
But what they're saying is the command itself is not hearsay. So
I don't have an issue with what Nichols said, because it would come in, if it were to come in, already as against his penal interest, potentially. But just assuming that that's not even hearsay, you still need to get to the part where Rel is repeating something.
And how are we supposed to accept Rel's hearsay statement that Nichols said X, Y, and Z?
Because Cormavius is saying it, Cormavius is giving the, so Cormavius is communicating not Cormavius, Quantavius Greer. Greer is stating what Rel
told somebody else.
That Cormavius said.
Right.
So if what Cormavius said isn't hearsay.
What Rel said is hearsay.
I understand.
Okay? So what's the exception for that?
What he said. If I understand it, Rel communicated what Cormavius said. So the only thing Rel said is what Cormavius said. And I guess maybe
That's
where
true. But given that we don't have Rel, it's hearsay. Whatever he says, even if when Nichols allegedly said it, it's not hearsay or it comes in under hearsay exception. The fact that Rel is repeating it and we don't have Rel here
and we don't have
means
Rel.
it's hearsay, right? Right.
Yes.
And so what's the exception? There isn't one. This cannot come in. And do you have one?
No, you're right. At this
Okay.
time, we don't.
All right, so that takes care of that.
Brian, can I ask you a question?
Yes, I may not know the answer, but
Can I just have 1 second?
sure. We still have a lot more to circle back on. Does anybody need, why don't we take a bathroom break while y'all do that? Okay.
Hey everybody, thank you so much for watching our coverage of the Young Thug trial. Now I want to take a quick second and I want to tell you about this stream's awesome sponsor, Upside. So what's Upside? Upside is a free app that gets you cash back on daily essentials like gas and groceries. So when I go to pump my gas, I can use the Upside app and get cash back. Real cash back. It's money that appears in your Upside app that you can transfer straight into your bank account. So once you have the Upside app, you claim an offer for whatever you're buying on Upside. You pay as usual using a debit or credit card. You follow the steps on the app and you get paid. And as you saw me just do, you can use Upside at places like Shell, Exxon, Mobil, 7-Eleven, Taco Bell. That's just to name a few, by the way. There are so many more. So to find out how much you could earn, click the link in the description to download Upside or scan the QR code on screen and use our promo code LCLive and you'll get an extra 25 cents back on every gallon on your first tank of gas. That's promo code LCLive for an extra 25 cents back on your first gallon of gas.
All right, so the next thing I see is on, back with the wiretaps, on reference number 2158. We were going to circle back on that one also.
And is that the one we dealt with yesterday on?
Yeah.
We're pulling it up.
Y'all were going to look at with others in narrow. No, never mind. Sorry, that was the next several. So I don't know why we were circling back on 2158, frankly.
Is that the 28-minute one you're on? There might be no. Okay.
I don't know. No, it's 40, I don't know how long it is. Anybody know?
No, Mr. Atkins is looking that up, and I'm going to go and get a speaker on this too.
Okay. Yeah. Mr. Atkins, do you remember why we were coming back to 2158?
Yes, Your Honor. It was,
Okay.
I was trying to find out who the called party was. 'Cause,
Right, okay.
At this point in time, this specific call, they're talking about going to blitz somebody, like shoot somebody.
Right.
And so I told the court that I need to know who Mr. Garlington is speaking with.
Right.
He mentions talking with Mr. Copeland, but, so at this point in time, the state does not intend to use this call.
Okay.
Because, so that's the state's position regarding that specific
All right,
call.
thank you.
Yes, Your Honor.
And then the next one, well, you were going to obviously look at a bunch of those that kind of dealt with the same thing, and if you hadn't had a chance to do that, yeah, that's fine. But the next one was, let's see, reference 1384, page number 1394. You were gonna get the timestamps together better, and then we were gonna take a look at it again. Have you had a chance to do that?
Your Honor, I want to double check if that's the one that was 28 minutes.
This was Dorsey.
Oh, understood. Speaking on Antonio Sumlin's wiretap.
Right. Yeah, oh, yes, I'm sorry. I switched pages and I didn't tell you that. I'm sorry.
That's all right, Your Honor. The state has not.
If you hadn't had a chance yet.
I have not yet, Your Honor, but.
Okay, that's fine. And then I had a tab by the one that's 0 or 1892. Was there something, maybe you were going to, I don't know why that one's noted. Polo.
Your Honor, can you say that PDF page number one more time?
1892.
And what was the court's notes regarding 1892?
I had a tab by it that I had circled the timestamps, but I don't know why. Sorry.
I know for that specific call, we were only intended on playing the first 40 seconds and 1 minute 30 seconds to 1 minute
Right.
5 seconds.
Yeah.
My memory, I'm trying to pull up that transcript, that there was a portion of one of those two sections that.
We're going to take, well, I mean, I'm looking at what y'all have summarized. I can come get you tonight. We can do that. I'm talking about hit that boy like 2 or 3 times. We're going to rock out on that tonight.
Correct, Your Honor.
Anybody remember that at all? Maybe I just randomly put a sticky tab there for no good reason. I don't know. Do you have a note that I ruled?
Your Honor, I'm trying to pull up my notes.
Okay.
I do not have a note.
Anybody?
On that note.
No idea. The second purple tab.
on that particular entry at all.
Your Honor, I'm trying to pull up my,
I know you are. I just meant like, well, I know you're looking. Does anybody else over here on this side of the room?
I don't have that.
Not yet.
Okay, well, in the meantime, while Mr. Atkins is looking for his notes, what other items can we handle today? I know at some point, Mr. Williams, and obviously Mr. Atkins came back in, so maybe there's more we can deal with on that. But I don't want to distract you, and Mr. Williams is gone again, so she's with Ms. Hilton now, still working on it. Okay, yes.
correct.
Yes, Your Honor.
All right, Mr. Matthews.
Yes, Your Honor. I'd like the court to consider Overt Act 102 on page 41 of the indictment. We've talked about it. It's been broached a few times, Your Honor, concerning a Chandler Durham. That name is ring a bell. All right. So in Act 102, Your Honor, it says that defendants Huey and defendants William engaged in a conversation indicating if he don't take it back, he gonna die. So that's the text message.
Okay.
And when the court goes to the indictment and deals with the alleged conspiracy, the court, they have indicted this case as indicating that the conspiracy is that the defendants conspire to associate together and with others for the common purposes of illegally obtaining money and property through a pattern of racketeering activity. So with the Durham facts, they're indicating that Chandler Durham, that his vehicle was taken while Chandler Durham was inside his music studio working, and he came outside and the vehicle was gone. So we have this text message that supposedly took place on March 12, 2020, where Williams is allegedly sending a text message to Huey, allegedly saying if he don't take it back, he gonna die. So I don't see, Your Honor, even if we look at the analysis under 801 D2E where it talks about out-of-court statements, how this furthers, how this is during the course and in furtherance of a conspiracy, if the conspiracy is to gain.
Hang on. Williams,
I'm sorry.
There is a text between Williams and Huey that says if he don't take it back, he gonna die?
That's correct.
Or directing Huey to tell another. Who's the other?
Directing Huey to tell someone if he don't take it back, he's going to die.
Do we know who the person is?
We don't know.
Do we know what the it is?
I'm thinking I'm speculating, but I'm assuming it has to do with Chandler Durham's vehicle that was taken outside Chandler Durham's studio when he was working one night. So if the conspiracy is to work together to illegally obtain property and money through the pattern of racketeering activity, thefts, murder, robbery, and the like, I'm not clear how this is furthering a conspiracy if Williams is telling Huey to tell someone if he don't take it back, he's going to die. So, I'm challenged with how this is an overt act in furtherance during the course of and in furtherance of a conspiracy.
And what are you asking the court to do about it?
Well, I'm asking the court to consider that this particular overt act is not an overt act in furtherance.
And just strike it or something?
Yeah. Yeah.
What relief are you requesting?
Yes. Bingo. Ding, ding, ding.
Your Honor, for one, this is two statements of party opponents. And so that's a great argument for closing, to tell the jury that how does this further the conspiracy. So I don't understand the exact relief that is being asked by the court, but the state's position is the state is going to introduce this message, and any argument about what they mean or how this furthers the conspiracy, we can both argue our separate positions to the jury in closing of if this furthers it or does not. And the jury can decide with this evidence of an overt act between two defendants in trial of a conversation that both of them had with one another.
See, the state can't have it both ways. They can't say that this conspiracy is to do these illegal acts, and then when there's supposedly something that totally cuts against the grain of an illegal act, is somehow furthering the conspiracy.
Okay, well, I mean, they're either going to, I mean, they may be able to prove that text occurred, but they may not be able to convince the jury that it's an overt act in furtherance of the conspiracy, especially with your apt argument to the contrary, that it seems to be the exact opposite of that. But yeah, I mean, I think that's a jury question.
Your Honor.
I didn't draft the indictment.
But the burden is on the prosecution by a preponderance of evidence to show that statement, which is Mr. Williams' statement. So I may have a different, Mr. Adams and I may have a different issue because we're a party opponent. But to use against Mr. Ryan or Mr. Kendrick et al., the state would have to meet that burden, not just say, well, both sides can argue it. They're going to have to show that statement furthered this conspiracy.
Okay, well, that's a different objection. To get to the evidence even coming in. Mr. Adkins.
Yes, Your Honor. I'm trying to pull up. I have a thorough, in-depth breakdown of this conversation, what's said before and after that. I can't rattle off memory this moment, and so I'm trying to pull that up, and my internet's not cooperating. So that's
Is
why
Chandler Durham?
He's not on the witness list.
He's what?
He's not on the witness list.
Okay. Is he allegedly in any gang?
No.
He's a very well-known, he's outstanding, like engineer, production person, does a lot of work for very well-known musical artists and other talented people.
Okay.
He's a very well-respected person.
Okay. Did Mr. Williams use him?
Yes.
Maybe that's why Mr. Williams wanted him to tell somebody to return his car.
And I think that, I'm joining. I will join, I heard the argument of Mr. Matthews. I will join his cogent argument as well. But I'm still stuck with, I don't see why that comes in. I do understand it's my statement, so I understand that the court may say, well, let's talk about your client, but to say it comes in against everyone, I don't believe that at this point, I don't believe that would be fair.
How that statement can be in furtherance of a conspiracy.
That's
good question.
Thank you, Your Honor.
Ms. Abbasi, do you have any idea, like, where they are, how much, if they have made progress, how close they might be to finishing?
I'll take a look.
Thanks.
I don't even want to make a guess.
Okay.
If they get progress. Not many agreements is what's, yeah.
Disappointing. All right, I tell you what, why don't we end for the day, make them keep working. Y'all letting them know they need to keep working. Ms. Abbasi, maybe you could assist in that?
Yes, Your Honor, I don't know if this is the type of thing that perhaps both sides could present to Your Honor what they think should be redacted. And Your Honor could make preliminary rulings, and if we want to argue further, we can do that. But that would be versus using the court's time with everyone sitting here listening to the back and forth.
I mean, that's fine with me if it's fine with everybody else.
Your Honor, I think that's a great idea. And
I'll discuss with the other attorneys how they feel about that. But I think that certainly would free up quite a bit of the court's time.
Yeah. I mean, yes and no. This just makes me have to do it as homework, but that's fine. Sometimes it's easier to
You can at least, do it in your PJs.
Yeah.
More comfortable.
That would be fine, as long as it's fine with all of the other defendants.
I'll touch base.
Okay. So, Mr. Atkins, just whenever you do, find your notes on that. And, it may, hate to say it, but it might be easiest to just look at the live stream,
Your Honor,
since we
that's
have it
correct.
available. Okay.
And specifically, that was Mr. Sumlin's 1842.
Yes, 1892.
Thank you, Your Honor.
Okay. All right, and then y'all are going to, when is it that we're going to, I don't know, when we're going to take up the contents of the cell phone, but the way we left that, I think, was that the state was going to get to the defense, the more narrow, what it is that the state intends to, or would like to use from that.
So about the phone document?
Yeah, of Stillwell, yeah.
So I have one, we can get to about my
That's fine. All right. So I think everybody has, are we going to pick back up on Monday with Bernie and finish with him? And then should we be able to generally follow the order that's there?
For the most part, Your Honor, now, if we're being excused now, I will get the list together that I normally will do on Fridays. Give me about,
Yeah.
and I'll send it out ideally the order that you'll have in there.
Okay, and I don't know how much time y'all need to get a response in on Mr. Steele's 3 motions he filed this morning. What do you think?
Can we have next Friday, just the 18th?
As long as y'all stay really, really on the ball with all of your witnesses for the coming week.
Yes, Your Honor.
If you don't, I'm gonna.
Yes.
All right.
Miss Hilton?
Yes, sir.
I know you're going to send it out later on, but could you just, while we're here, just tell me Bernie and then who's next after that?
Yes.
Well, you had Sprinkle, but I mean, we're not jumping back to him right now after Bernie, are we?
I thought we we're going to have a few in between Bernie and Sprinkle. That's what I thought.
So what we have for Monday, and this is all contingent upon when Agent Bernie finishes, Officer B. Peak, Officer J. Williams.
A little louder, please.
Hang on. So,
Sure, I can tell you from it. So B. Peak is,
he's witness number 8. So it won't be McGee, it'll be Peak?
yes, Your Honor.
Okay.
J. Williams, which he is on.
I'm sorry, Ms. Hill.
You need to talk closer to the mic, I think.
J. Williams, who is number 9.
Yep.
Number 14.
Can you try the mic again, please?
I don't know how much closer are the mic can be in my mouth.
Is it on?
It says it's on.
Doesn't sound like it.
I don't know. We're back with all kind of sound issues again today. I think these things must just drain batteries.
Okay.
All right.
Can you hear me now?
Yes,
All
better.
right.
Woo.
Could you start?
Sure can.
Thank you.
No problem. Officer B. Peak, who's number 8.
Yep.
Officer J. Williams, who is 9 and 14.
Okay.
Ms. Good, who is 15, and she'll be talking about 2 incidents. Sergeant Fernandez, who's number 16. Crime Scene Tech Green, who is 39. Officer S. Holt, who is 40. And Officer J. Johnson, who is he is at 198 staying home, number 30.
Okay.
Thank you.
Excuse me, will any of those be on video blackout requested not to be shown?
Good question.
None of those individuals, no.
Thank you.
Okay. And that's just for Monday, right?
Yes, Your Honor.
Okay. All right, so you'll send the rest of the list out later today.
Yes, Your Honor.
All right. We are adjourned.
Thank you.